Online students, good afternoon to all of you. Please write down the next topic, bills. Okay, just write down a line as to what is a bill. It is not bills. Okay, write down just bill. So write down a line. What is a bill? A bill is a legislative proposal which is introduced in the legislature. Introduced in the legislature and approved by the legislature. Approved by the legislature before it becomes an act. Before it becomes an act. Before it becomes an act. Okay. Before it becomes an act. A bill, write down, a bill has no legal sanctions. A bill has no legal sanction before it becomes an act. Before it becomes an act. Before it becomes an act. Depending upon who is introducing a bill, a bill can be classified into two types. Depending upon who is introducing a bill can be classified into two types. What are the way by which the bills can be introduced? Depending upon who is introducing the bill can be classified into two types. So what are the ways it can be classified? Types of bill, you call that as a government bill and a private member bill. How do you classify? It is classified into a government bill and a private member bill. So that's how you classify. Understand? It's classified into a government bill and a private member bill. So what do you mean by a government bill? So first of all, tell me who can introduce a bill. The members of parliament can introduce a bill. I said that you just relate with the previous topic, whatever you have learned. You have just seen in our previous classes that although we have separation of powers, we do not what is called as strict separation of powers. Is there strict separation of powers? Why do we say that there is no strict separation of powers? There is some element of overlap between the legislature and the executives. That means the ministers is also part of the legislature. But not all those people who are part of the legislature are ministers. Only few people are ministers. The remaining are only part of the legislature, but the ministers are also part of the legislature. So what do you understand by a government bill? A government bill means a bill which is introduced by a minister. That's basically what is called as a government bill. Now, in the present government, anyways, elections are going on right now, but still we have a government. Can you name any of the ministers at the union level? Mr. Piyush Goyal. Any other minister? Mr. Modi himself is a minister. He is a prime minister. He is also a minister. Mr. Amit Shah, Mr. Rajnath Singh. But they are also members of parliament. Are they members of parliament? They are also members of parliament. So, but they are also members of parliament, but they are also ministers. That is, they are both part of the legislature as well as the executive. That's why we say that we do not have a clear separation of powers. But then we do have what is called as the checks and balances. Now try to understand this. Any bill which is introduced by what? By a minister is what is called as a government bill. So depending upon who is introducing it, if a minister is introducing a bill, then that bill is termed as what is technically called as a government bill. And then what is a private member bill? Anybody other than the minister. Who is a private member? Who is a member of parliament but not a minister. These two are mutually exclusive. So any member of parliament other than the minister, if he introduces a bill, that is what is called as a private member bill. Can you give me an example of a private member in the parliament today? Very good. Mr. Rahul Gandhi, some voice is coming. Just tell them to check it. So, for example, Mr. Rahul Gandhi is a private member. And there can be number of other MPs. Okay, so but whoever is not a minister is a private member. Okay, so depending upon who is introducing the bill is what is called as 4 types. What are the ways that they are classified? Sorry, depending upon who is introducing the bill, it is classified into government bill and what is called as a private member bill. All right. So write down what is a government bill. A bill which is introduced by a minister. A bill which is introduced by a minister. A bill which is introduced by a minister. Some voice is coming, kind of echo. A bill which is introduced by the minister is a government bill. Write down the second thing, a private member bill. Bill which is introduced by a private member. A bill which is introduced by a private member is a private member's bill. Any member of parliament, just continue writing, any member of parliament who is not a minister, any member of parliament who is not a minister is a private member. Any member of parliament who is not a minister is a private member. Is that clear to all of you? So it should be very clear as to who is a minister and who is a private member. What is a government bill and what is a private member bill. So this is depending upon who is introducing that. And write down, the bill can also be classified on the basis of its subject matter. The bill can also be classified on the basis of its subject matter. What do you understand by subject matter when I say that the bill can also be classified on the basis of subject matter? Huh? Whether it is a... What do you mean by subject matter? One thing. I'm just trying to understand. What do you understand? I've said that the bill can also be classified on the basis of subject matter. So, for example, as a part of your general studies, you need a number of subjects. You read Indian Polity, you have to read history, you have to read geography, economics, environment, science and technology. You say that to be these are different subjects. Now, what actually makes this subject to differ from one another? The content, the subject matter of the subject that you are studying. The subject matter is not the same. So similarly, it may be a bill which is introduced by a minister or by a private member. It can be a government bill or it can be a private member bill. But whenever they introduce some bill, the subject matter, the content in those bills can be really different from one another. So depending upon that, how the bills can be classified. So write down the different types of bills in terms of the subject matter. I would say in terms of the subject matters, the bill can be classified into financial bill. 2, ordinary bill. 3, constitutional amendment bill. So depending upon the subject matter, how they are classified: financial bill, ordinary bill, and constitutional amendment bill. Further, this financial bill is further subdivided. There are different types of financial bills. Further, how they are subdivided? They are classified into money bill, financial bill type 1, and financial bill type 2. So this is how they are classified. So how they are classified? They are classified into money bill, they are classified into financial bill type 1, and they are classified into financial bill type 2. And then you have an ordinary bill and you have a constitutional amendment bill. So these are the ways by which they are classified. I'm not going to explain as to what the subject matters are. Right now, just try to understand, depending upon the subject matter, how they can be classified. They can be classified into financial bill, you have ordinary bill, and you have a constitutional amendment bill. Just that one thing that you have to remember. What do you mean by a constitutional amendment bill? Any change that is proposed to be made in the constitution. If the subject matter of the bill is what? It is trying to make some changes in the constitution. then such types of bills are called as constitutional amendment bill. And what do you mean by a financial bill? What is the general subject matter? There's some difference depending upon the type of financial bill. I said that the financial bill can be further classified into these three types. But in general, what do you mean by a financial bill? A financial bill is something which deals with the financial matters of the government. It can be revenue, it can be expenditure, some financial matters of the government. That's basically a financial bill. And then what is an ordinary bill? But depending upon the expenditure further, depending upon the matter, the revenue matter or the expenditure matter, it is further divided into all the three types, which we'll subsequently discuss. If I discuss all those things right now, you will not understand. So what is an ordinary bill? Any bill whose subject matter does not fall under a constitutional amendment bill or the financial matters, then such bill is what is called as an ordinary bill. Okay, so this understanding you should have at this stage when you are beginning it. So probably you'll have all these understandings. So what are the understanding you should have? So the first thing is the subject. So depending upon who is introducing a bill, the bill can be considered into what? The government bill or a private member bill. Two, depending upon the subject matter, it is classified into what? It is classified into financial bills, ordinary bills, and the constitutional amendment bills. But further, the financial bills are also classified into these three types. Is it clear to all of you? So basically, what is a bill? A bill is merely a legislative proposal. Can those bills be implemented? It cannot be implemented unless and until it becomes an act. So when it becomes an act, it can be implemented, but not before that. All right. So write down the next thing. What is the next topic? Assent. Write down the next thing, that is assent. Assent. Assent is a process. Assent is a process. Assent is a process by which the president gives the approval to the bills passed by the legislature. Assent is a process. Assent is a process by which the president gives the approval Assent is a process by which the president gives the approval to the bills passed by the legislature. Assent is a process by which the president gives the approval to the bills passed by the legislature. In the process of giving the assent, the president can exercise certain veto powers. In the process of giving the assent, the president can exercise certain veto powers. In the process of giving the assent, the president can exercise certain veto powers, which includes absolute veto, two, suspensive veto, which includes absolute veto, suspensive veto, suspensive veto, and packet veto. Okay, just listen to me for a moment. But however, I said that the word veto is nowhere mentioned in the Constitution. It's only an implicit power that the president exercises by virtue of Article 111 of the Constitution. We already heard about that, but what these veto powers are, we'll see that later. Just add one more line to that. However, the president cannot exercise his veto powers. However, the president cannot exercise his veto powers as a constitutional discretion. However, the president cannot exercise his veto powers as a constitutional discretion. Rather, he uses most of these veto powers. He uses most of these veto powers as a situational discretion. He uses most of these veto powers as a situational discretion. Now, what do you understand by constitutional or situational discretion? I gave an example. So anyone give me an example of the constitutional discretion and the situational discretion? Hung parliament. When there's a hung parliament, who is appointed as the prime minister is a situational discretion. And what is a constitutional discretion? Article 74, that the president will always have the power to send any proposal that is sent to him once for reconsideration. That is his constitutional discretion. Is that clear to all of you? Come to the next keyword. What is the next keyword? Collegium. Okay, so write down the next word, collegium. Collegium. Collegium refers to a group of people. Collegium refers to a group of people who makes recommendation. Collegium refers to a group of people who makes recommendation regarding the appointment of is there any issue with the voice? Just give me a moment. Online students, is there any issue with the voice? Okay, so Ashish, the others do not have any problem. Just try to check your system that you are using or whatever device that you are using. So try to adjust the volume from your side. Okay, what is collegium? So collegium is a group of who makes recommendations with regard to appointment to some public office. Who makes recommendations with regard to appointment to some public office. Collegium is a body or it is a group of people who makes recommendations with regard to appointment to some public office in the Indian context, right? In the Indian context. In the Indian context, collegium refers to group of senior judges. Group of senior judges in the Supreme Court. Group of senior judges in the Supreme Court who makes recommendation to the President of India. Who makes recommendation to the President of India. Who makes recommendation to the President of India with regard to appointment of. Who makes recommendation to the President of India with regard to appointment of. With regard to appointment of the judges of Supreme Court. With regard to appointment of judges of Supreme Court and High Courts. With regard to appointment of judges of Supreme Court and High Court. So can anyone tell me what constitutes a collegium today? So these are the senior judges in the Supreme Court who makes recommendation to the President with regard to appointment of judges of the Supreme Court and High Court, and this recommendation is binding upon the President. That's very important. So can anyone tell me as to who constitutes collegium in the Supreme Court today? Very good. Today it constitutes, what is a collegium? It consists of Chief Justice of India plus 4 senior judges, or I would say 4 senior most judges in Supreme Court. It constitutes Chief Justice of India plus 4 senior most judges in the Supreme Court who makes recommendations with regard to appointment of judges to the Supreme Court, and for the High Court, it is not the collegium. For appointment to the judges of the Supreme Court, it is a collegium. And this collegium, it is not only about the appointment. Just listen to me. It is not only about the appointment. It also makes recommendation to the President with regard to the transfer of judges from one High Court to another High Court. Do you know the judges of the High Court may be transferred, which is possible under the Constitution? But only the judges of the High Court, because for the Supreme Court, there's only one bench. There's only one seat, rather. So they cannot be transferred, but there are different high courts. So the judges of high court can also be transferred. So this is a collegium for whom? For the appointment of judges of the Supreme Court. And this is also the collegium which deals with recommendations relating the transfer of Judges of what? Judges of High Court or High Courts. So then there is also Collegium with regard to appointment of judges to the High Court. So for that, what is a Collegium? So there is one more Collegium, that is Chief Justice of India plus 2 senior most judges. Plus 2 senior most judges of Supreme Court. So this is the Collegium with regard to appointment of judges to High Court. So try to remember, there are 2 different Collegium. When it comes to appointment of judges to Supreme Court and transfer of judges in case of High Court, the Collegium is the same. For the appointment of High Court, the Collegium is different. But try to understand that this Collegium recommendation is binding upon the President. But most importantly, you'll have to understand that there is no mention of Collegium in the Constitution. Write down one more line. The word Collegium is nowhere mentioned in the Constitution. There is no mention of the word Collegium in the Constitution. It is only the Supreme Court of India. It's only the Supreme Court of India. It's only the Supreme Court of India has innovated the Collegium. It's only the Supreme Court of India which has innovated the system of Collegium. Has innovated the system of Collegium in a series of judges cases. In a series of judges cases. In a series of judges cases. There are certain cases which is called as judges cases. So in those cases, the Supreme Court came out to this particular idea of what is called as the Collegium system, which we'll subsequently later discuss. Okay, as of now, this much basic information is more than sufficient. So what is this body Collegium? Is it mentioned in the Constitution? It is only innovated by whom? The Supreme Court, because we know that whatever the Supreme Court says it is a Constitution of India. Because who is the ultimate interpreter of the Constitution? It is the Supreme Court of India. It is just something which is innovated by the Supreme Court, similar to that of the basic structure. Have you ever heard of the term basic structure? This basic structure is also innovated by the Supreme Court. Although I have not discussed about this, it was innovated by the Supreme Court in a case which is called as the Keshavananda Bharati case. So similarly, this was also innovated by the Supreme Court. Okay. So come to the next keyword. What is the next keyword? Suo Moto. Okay, write down the next thing, that is Suo Moto. So it is called as Suo Moto, or somewhere it can also be mentioned as Suo Motu. Suo Moto or Suo Motu. Suo Moto or Suo Motu. So what do you mean by Suo Moto or Suo Motu? Now, how many of you are following the elections today? So just to connect with this particular topic. Now, there's a lot of allegations against the Election Commission of India today. I am using the word allegation. Okay, it's people are making the allegations. The opposition political parties are making allegations that the Supreme Court of India, the Election Commission of India has not acted against the present Prime Minister of India. So the allegation against him is that he has used language as he has used religion as a ground to divide people, probably to increase his electoral prospects or the prospects of the party. That's an allegation which is happening right now. Now, what is the primary role of the Election Commission of India? To ensure that the election is following the principle of free and fair elections. They have to ensure a free and fair election. And it is Election Commission of India which has to ensure the free and fair election, for which there are certain laws in our country also that would empower the Election Commission of India to ensure free and fair election. Already the Election Commission of India is directly getting a lot of powers from the Constitution. In addition to the powers that is given to the Election Commission of India under the Constitution, there are a lot of other ordinary laws as well, which does empower the Election Commission of India to ensure free and fair election. In fact, in the very first class, when I was discussing about the syllabus, I spoke about one law which is called as a Representation of People Act. How many of you remember Representation of People Act? I discussed about this. I remember RPA, which is nothing but RPA 1951, which is nothing but the Representation of People's Act, which is basically an election law in our country, which enables the Election Commission of India to ensure what is called as the free and fair election. If you look into this Representation of People Act, the Representation of People Act says that there is a section which is called as section 123 of the Representation of People Act. So similar to that of the articles that you have seen in the Constitution, if you see the ordinary law, they use the word section. So what is the definition that I have given for articles? It's a specific rule in the Constitution. Similarly, in the ordinary laws, every section is a specific rule. If you look into the section 123 of the Representation of People Act, it says that if anybody engages to divide people on the basis of religion, race, caste, whatever be it, during an election speech, that's a ground for their disqualification from contesting election. So now the allegation is why the Election Commission, which is having the authority to act against the Prime Minister in case if he has used such a word and if it is proved, why don't the Election Commission of India is making an inquiry and why it is not acting against the Prime Minister? That's why some of the political parties are making an allegation that the Election Commission of India is not conducting a free and fair election. That is on the one hand. Now coming to the idea of what is Suo Moto or Suo Motu. Now many of the social activists, they also come and said, okay, if the Election Commission of India is not acting, that is okay. The Election Commission of India should act. If it is true, they should act. But in case if they are not acting, why don't the Supreme Court of India intervene and take up this matter Suo Moto or Suo Motu? So that is what number of people are coming and saying. So what do you understand by this word? Why don't the Supreme Court of India come and take up this matter Suo Motu or Suo Moto? So what do you understand by the word Suo Moto or Suo Motu? On its own. That is basically what is called as Suo Motu. That means there is no need to file a complaint. The Supreme Court of India has a lot of powers and they can initiate certain things on their own in the interest of the public. That is basically what is called as Suo Motu. So please write down a line as to what is Suo Motu. Suo Motu or Suo Moto means on its own. On its own. On its own. On its own. Which means a particular matter may be taken up for investigation. A particular matter may be taken up for investigation or trial by a competent authority without a formal complaint being filed in front of it by another party. Without a formal complaint being filed in front of it by the concerned party or other party, by the concerned party, by the affected party or concerned party or the affected party. Formal complaint being filed in front of it by the affected party. Okay, so you understand the meaning of Suo Moto? Suo Moto means that on its own it can take up this particular matter. The others do not have to bring this matter to the concerned authority who has got the authority to conduct the trial in this particular matter. That's the allegation. Why don't the Supreme Court of India take up this particular matter Suo Moto? So this may apply to any of the other authorities as well. Whenever I use the word Suo Moto, on its own. Okay, that's the basic understanding you should have. So write down the next keyword. What is the next keyword? Public interest litigation. Write down the next thing. Public interest litigation. Public interest litigation. So how many of you heard about this word public interest litigation? Is there any other keyword apart from public interest litigation? Have I mentioned the word locus standi? Or it is not mentioned? It is not mentioned. Okay. So write down the next keyword, that is public interest litigation. It was public interest litigation. Okay, before I get into this keyword public interest litigation, you should understand the keyword what is called as locus standi. So once you understand locus standi, then I'll go into this particular matter of what is called as public interest litigation. Has anyone heard of this word locus standi? What does it mean by locus standi? Okay, just write down a note somewhere. First, let us try to understand the word locus standi, and then I'll get into the concept of public interest litigation. Locus standi is a principle that is followed in the judiciary, or a traditional principle. You can write out it's a traditional principle followed in the judiciary. A traditional principle followed in the judiciary only the affected person should knock the doors of the judiciary. Only the affected person should knock the doors of judiciary. Or in other words, only the affected person should knock the doors of the judiciary. Or in other words, it means what is your interest? In other words, it means what is your interest? In other words, what is your interest? Now listen to me for a moment. That means tomorrow, let us assume that you file a case in the Supreme Court to accept that particular case. Not, you know that a number of cases which is filed, especially in the higher judiciary, they get dismissed. It is not that each and every case will be entertained. So the first thing that the judges are going to ask whenever somebody is filing a petition, they will ask you, what is your interest in this case? Or in other words, in which way you are affected because of this case? Show me that in which way you are interested. Then I'll take up this matter. That's basically what is called as the locus standi. Now, over a period of time, a new principle has emerged in our Indian judicial system, which has carried forward from the Western countries, is a concept of what is called as public interest litigation. So what is this public interest litigation is saying? That the traditional principle is locus standi, which means that anybody who wanted to file a case, they should be personally affected because of that. Then they can defend their rights, they can take it to the court of law, they can seek the remedy. But what is this principle of public interest litigation? So public interest litigation says that not necessarily the affected person has to file a case. Any interested person, although he is not directly involved in this particular case, he can also bring this matter to the notice of the court in the interest of the general public. He is not affected. But why he is filing this case? Because the other people in the society are getting affected. So as a responsible citizen, although he has no personal interest directly, but on behalf of others, he is filing this particular case. So whenever somebody is filing a case in the court without following the principle of locus standi, then it becomes what is called as a public interest litigation. Have you ever heard of this particular word in the newspaper? A public interest litigation has been filed. A public interest litigation has been filed. In fact, recently, the Supreme Court has declared one scheme of the government as unconstitutional. Can anyone tell me what is that scheme which was declared to be unconstitutional by the Supreme Court? The electoral bond scheme. Most of you might have fair idea about it. We'll discuss at the later stage. Right now, it is not relevant if required. So this electoral bond scheme has been declared to be null and void, unconstitutional by the Supreme Court. But do you know how this matter was taken up? How the matter was filed in the Supreme Court? It was filed as a public interest litigation. A public interest litigation was filed by a number of people, and one prominent NGO among that is the Association for Democratic Reforms, who wanted to bring in a lot of electoral reforms in our country. So they were not directly affected because of this, but they thought that a lot of people might get affected because of this. So on behalf of the people and others, they filed this litigation in a court of law. And such litigation is what is called as public interest litigation. Okay, so just write down a line as to what is this public interest litigation. Public interest litigations are those litigations. Public interest litigations are those litigations Public interest litigations are those litigations. Public interest litigations are those litigations which is not filed by the affected individual. Okay. Public interest, just small correction. Public interest litigations are those litigations which are filed in a court of law. Which are filed in a court of law. Which are filed in a court of law without following the principle of locus standi. 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 Public interest litigations are those litigations which are filed in front of the courts without following the principle of locus standi. In other words, these litigations may be filed. These litigations may be filed by any public spirited individual. By any public spirited individual by any public spirited individual and not necessarily the affected individual. In other words, these litigations may be filed by any public spirited individuals and not necessarily the affected individuals in the interest of protecting the rights of others in the society. In the interest of protecting the rights of others in the society. In the interest of protecting the rights of others in the society. Now, just tell me what could be the advantage of this public interest litigation. Now, initially this concept was not recognized by the courts, but as and when time progressed, the courts also recognized, and the concept of public interest litigation becomes so popular in late 1970s and after that in our country. Now, what is the advantage of this public interest litigation? Check and balances by. So anyways, that if you are affected, you can go to the court. Now, why would someone who is not directly interested is allowed to file a case in a court of law? That's the question. Checks and balances means by providing fundamental rights, and for the violation, you are already allowed to go. If your right is violated, you are allowed to go. If my right is violated, I am allowed to go. But if your right is violated, my right is violated, you are not going, I am not going, but somebody else is going and filing on our behalf. The most important thing is, if you see in our country, on the one hand, the constitution guarantees the right, but how many of you do you think has got the resources to enforce their rights when it is violated? Going to a Supreme Court and filing a case, do you think it's an easy thing? Do you know how much a Supreme Court senior advocate would charge? Any idea? Has anyone gone to the court till this point of time? I wish that you don't come across such an experience going to a court and fighting a case in a court of law. Especially in the Supreme Court, do you know how much they charge? There are advocates, senior advocates, they charge. I would say that the least thing that you can expect from any lawyer today is 1 lakh rupees per hearing. I was saying the least thing, 1 lakh rupees per hearing, which means the hearing can last for 1 minute or 2 minutes. 1 lakh rupees, even if it is for an hour also, per hearing they charge. But the hearing can go as less as even 1 minute also, even less than that. And there are lawyers who charge up to 25 lakhs, 30 lakhs, 40 lakhs per hearing. And do you think a common man can afford this much? And that is how the costly is. So under such a circumstances, if somebody is not able to fight for their rights, so there are public spirited individuals. They may have their own resources, not necessarily that they may pay, but they can be lawyer themselves. So, or somebody who can act in pro bono without filing. So, but they may have the connections. So in this way, the public interest litigation is allowed to bring to the notice of the judiciary if people themselves are not able to fight. So considering this, the judiciary has accepted, and today it has allowed this particular principle of what is called as the public interest litigation. All right. So what is the next keyword? So are you clear about the concept of locus? What is locus standi? What is public interest litigation? Write down the next thing, that is tribunals. Write down just one line and then I'll explain. Tribunals are quasi-judicial bodies. Tribunals are quasi-judicial bodies. Tribunals are quasi-judicial bodies, which means the function of these bodies, is similar in character as that of the judiciary, but however they differ from the judiciary in certain respects. However, they differ from the judiciary in certain respects. For instance, write down the example. For instance, can anyone give me an example of tribunal that you know? Very good. The National Green Tribunal is a tribunal. So examples I'll write. National Green Tribunal, NGT. Have you ever heard of CAT? Central Administrative Tribunal. For instance, right? For instance, NGT and CAT, that is Central Administrative Tribunal. For instance, the National Green Tribunal and the Central Administrative Tribunal, They also take up cases. They also take up cases. However, their jurisdiction is much restricted. However, their jurisdiction is much restricted in comparison that of judiciary. However, their jurisdiction. Have you ever heard of this word jurisdiction? However, their jurisdiction is much restricted than that of judiciary. However, their jurisdiction is much restricted than that of judiciary. What do you understand by jurisdiction? Jurisdiction means, okay, in general area, but when it comes to the judiciary, the concept of jurisdiction means what are the nature of cases they can entertain. What are the nature of cases they can accept and look into those cases. That is basically what is called as jurisdiction. So when you take off the National Green Tribunal, what is their jurisdiction? They can look into only environmental cases. And what about the Central Administrative Tribunal? They can take up cases which are only administrative disputes. What do you mean by administrative disputes? Suppose, say for example, tomorrow you get into the service. How many of you want to get into Indian Administrative Service? Please raise your hand. Which IAS is your first preference? Anybody who's willing to get into IPS as your first preference? Okay, so the IPS are lastly in the back rows. Okay, so IPS. Anybody wanted to get into the foreign service as your first preference? All right, no foreign service. Okay. Irrespective, that is your choice to make. All the services are equally good. Now, tomorrow let us assume that somebody is getting into IPS, and then let us assume that there is an arbitrary transfer. A minister is coming and telling you to do something, but you feel that I'm not going to listen to that. And then some arbitrary transfer is happening. So in such a cases, you feel that it is completely an arbitrary transfer. There's no rule to transfer you, let us assume, because you will have to be done as per the rules, whatever is done. And then you have gone through the All India Service rules. Now you understand that such an arbitrary transfer cannot happen. So will you be able to fight against that? Will you be able to file a case against that? If there is an arbitrary transfer, or let us assume that you are not obeying to the whims and fancies of the minister probably. So there is an arbitrary promotion. A junior is being promoted ahead of you in the service. So will you be able to file cases against such actions? You do have the right. You do have the right, but you cannot go to the High Court, or you cannot go to any district court, or you cannot go to the Supreme Court directly. In such cases, where you will have to go? You will have to go and file a case in what is called as a Central Administrative Tribunal. So the Central Administrative Tribunal is a court which is there to look into the dispute between the central government employee and the central government. So you are a central government employee, and there's a government order which is there an arbitrary transfer, let us assume. Then you can file a case against that. But where you can file it? Only in the administrative tribunal. So similarly, every state have their own state administrative tribunal. So that is between a state government and a state government employee. So tribunals mean what? They also look into the disputes and all those things. But one of the major difference between, there are other difference also. But one of the major differences that their jurisdiction is very, very restricted, very, very narrow. But what about the courts? Let us assume take the high courts, take the Supreme Courts. The Supreme Court can entertain this dispute also, but not directly by way of an appeal. They can entertain this, they can entertain violation of fundamental rights, they can entertain federal disputes between the center and the states. They can entertain any dispute for that particular matter. So who is having a wider jurisdiction? Or in the sense, courts generally have a wider jurisdiction, but whereas tribunals have what? They have a very specific jurisdiction. And not only this, one of the important advantages of tribunals is that the procedure that is followed in the tribunals. In the tribunals, see, while conducting a trial, a specific procedure has to be followed. While if you look into the procedure that is to be followed in the tribunals, all that the tribunal has to do is the tribunal has to ensure the principle of natural justice. There's no specific procedure that is laid out, but all that they have to mention or maintain is that they have to ensure the principle of natural justice. Does anyone know what is this principle of natural justice? This is something that they have to ensure. What does it mean by the principle of natural justice? Okay, no issues. Online students, what do you understand by the principle of natural justice? So one important principle is that both the parties should be given an equal opportunity. Both the parties should be heard. Suppose if there are two people coming to me, suppose let us assume I'm a person who has to adjudicate this dispute. I'm a judge, let us assume. If both the parties are coming to me, I should hear both the parties. If I'm just hearing one party and if I'm passing the order, that does not follow the principle of natural justice. Because every person should be given an opportunity to represent himself. And then I have to analyze and then pass a judgment. So both the parties has to be heard or should be given an equal opportunity. The second thing with regard to principle of natural justice, nobody should be a judge of his own case. That again violates the principle of natural justice. So the judiciary in general, if you see the tribunals in general, that there is no specific procedure that is laid down for these tribunals. If they want to follow, they can follow the laws of the land. There are a number of procedural laws. But if they want to bypass that, they can also bypass that. But all that they have to ensure is what? They have to follow the principle of natural justice. But when you come to judiciary, say you take the example of district courts, high courts, or for that matter, Supreme Court. The Supreme Court, the high courts, and the other courts in our country, they have to follow the procedural laws. The procedural laws already enforces, they follow the principle of natural justice, but it's a very complex process. So here the process can be little simple. They have to just ensure that the principle of natural justice is followed. So what is your understanding of tribunals? Tribunals are quasi-judicial bodies which are similar to that of the courts in terms of their duties, but differ from that of the judiciary in certain respects. One important thing could be that their jurisdiction is much narrow, and then their procedure that they can follow is little liberal in terms that they have to ensure only the principle of natural justice. So that kind of flexibility is not there in the courts. Okay, and there are of course other differences also, but I'll discuss all those things at the later stage. Now it is just to give an essence of what these key terms are. So what are the things that you have understood? Just a moment. So what we have started with bills, and we have understood different types of bills depending upon who is introducing, depending upon the subject matter. And then we moved on to assent, and then we moved on to the term collegium, and then Suo Moto, public interest litigation, and then we have come to the word tribunals. Yes, what is your question? Yes, they can go to appeal to the High Court. Against the order of the tribunals, they can go to the High Court. And if they're not happy with the judgment of the High Court, against the order of the High Court, they can go to the Supreme Court. So initially, they cannot go to the High Court and the Supreme Court. Of course, if they're not happy, they can go to the highest law of the land. That is, of course, the Supreme Court, but only by way of an appeal, not direct. All right. Online students, yes. So Vaishali has told me that, sir, please do interact with the online students as well. Yes, of course. It's just that when you get into the discussion that you are carried away a little, not an issue. You can always put your comments. But of course, because the offline students are directly in front of me, I do know what is their expression and all those things. So that is not there in case of the online students. But yes, we do ensure a principle of natural justice in the class also. Both the online students and the offline students are equally important. Okay. Yes, what is the next thing? Constitutional bodies. So write down the next thing, that is the constitutional bodies. Constitutional bodies. Constitutional bodies. So what do you understand by constitutional bodies? Which we already seen, a constitutional body is something which is directly established by the Constitution of India. So can you give me examples of the constitutional bodies? So just write down this line. Just write down this line. And then after that, this is the last keyword, or we have some other statutory bodies, and then that's the last thing. Okay, so once I complete the keywords, I'll take up, if you have any queries, both online students and offline students, for 5 minutes, I'll take it up. Okay, so but let us try to complete both these keywords. So what is a constitutional body? Constitutional bodies are those bodies. Constitutional bodies are those bodies which are directly established by the Constitution of India. Which are directly established by the Constitution of India. So such bodies are what are called as the constitutional bodies. Example. Election Commission of India, Article 324. This is the Election Commission of India. And then Article 148, you can put the Office of the Comptroller and Auditor General. And then you can write Article 280, Finance Commission. Article 315, Union Public Service Commission and the State Public Service Commission. Article 338, National Commission for Scheduled Caste. Article 338A, National Commission for Scheduled Tribes. Article 338B, National Commission for Backward Classes. National Commission for Backward Classes. Just give me a couple of minutes, online students. We'll just complete this topic and then I'll take up your doubt. So these are all considered to be the constitutional bodies. So what is the understanding you have when I say that these are constitutional bodies? These are established by what? By the Constitution of India. Okay, by the Constitution itself establishes that. Usually the students have a misunderstanding. They think that if a word is mentioned in the Constitution, then they are constitutional bodies. No, in fact, there is mention of tribunals. But tribunal is not a constitutional body. Say, for example, you are discussing about the tribunals, which include the Central Administrative Tribunal. The word tribunal is mentioned, but all these tribunals, although there is a mention, the Constitution says that these tribunals shall be established by an act of Parliament. So if something is established by an act of Parliament, then such a body is called as what? It's a statutory body. So what is a constitutional body? Only when they are directly established by the Constitution. Now, what is the advantage? Why do you think that certain bodies has been established in the Constitution itself or established by the Constitution itself? It makes them really powerful because tomorrow if these things has to be changed, there's a need for a constitutional amendment. And it is very difficult to make a constitutional amendment. But suppose if a body is a statutory body, let us assume. Statutory body is something which is established by the ordinary law. Amending the ordinary law is very easy, but amending the Constitution is not that easy. So the Constituent Assembly, when they drafted the Constitution, they thought whichever body is very important to our political system for the proper functioning of our country, they have tried to ensure the constitutional status for that. But there are certain bodies which also is still important, but not as important as that of the constitutional bodies. They have been given a statutory status. Okay, so write down the next thing, statutory bodies. Online students, you need to wait for a couple of minutes. I'll just complete this topic and then I'll take up your doubt. Okay, so write down what is a statutory body. These are bodies. These are bodies which are established. These are bodies which are established. These are bodies which are established. These are bodies which are established either by an act of Parliament. These are bodies which are established either by an act of Parliament or by an act of state legislature. These are bodies which are established either by an act of Parliament or by an act of state legislature. These are bodies which are established either by an act of Parliament or by an act of state legislature. Now you give me an example of a statutory body, which is not directly established by the Constitution, but a law passed by the Parliament or by the law passed by the state legislature. Very good. NGT. CBI is not a statutory body. I'll come to that. CBI is a body which is established by an executive order. There is certain other things apart from the constitutional body or a statutory body. I'll discuss that a little later, not at this stage. But CBI is not a statutory body. Yes, National Green Tribunal is a statutory body because which is the law based on which a National Green Tribunal is established? National Green Tribunal Act. There's an act which is called as a National Green Tribunal Act based on which the National Green Tribunal is established. What about Reserve Bank of India? What is the status of Reserve Bank of India? Reserve Bank of India Act 1934, based on which the Reserve Bank of India is established. So what is the status of the Reserve Bank of India? It's a statutory body. Okay. What about the Information Commission? The Central Information Commission, State Information Commission. These bodies are established based on the Right to Information Act. So that's a statutory body. Have you ever heard of National Commission for Women? How many of you heard about this? The National Commission for Women, they can look into the violation of rights of women. The National Commission for Women is established based on the National Commission for Women's Act. So all these bodies which are established by an act of parliament or by an act of state legislature, they're all called as statutory bodies. Just write down the examples very quickly. What are the examples? Say, for example, National Green Tribunal is a statutory body. Then you have the RBI, which is a statutory body. As I already said, National Commission for Women is a statutory body. What are the other examples we have discussed? Central Information Commission. Have you heard of Central Vigilance Commission, CVC? Central Vigilance Commission is passed by the Central Vigilance Commission Act. So in general, you try to understand anything that is established by an ordinary law of parliament or an ordinary law passed by the state legislature, then that bodies are what is called as statutory bodies. There are hundreds of statutory bodies. You don't have to remember everything. But then you should understand the principle. When it is called as a constitutional body, when it is called as a statutory body. And in fact, today UPSC is coming out with this theme in most of the years in the preliminary examination. They give a list of bodies and ask you to identify which of the following is a constitutional body. But you can definitely remember the constitutional bodies because the constitutional bodies are very limited in the constitution. Maybe a few more than this, as we'll discuss later. So once you remember the constitutional bodies, the remaining bodies are mostly statutory bodies. Is that clear to all of you? All right. So what is the understanding we have had till this point of time? So right from the very beginning, if I take, this is our 4th class. So right from the very beginning, first, we are trying to let you understand the entire syllabus, especially with regard to the GS paper 2. Then we have taken baby steps in understanding what is the constitution, what is a state, what is constitutionalism. And then we have gone through some of the characteristic features, especially understanding the concept of democracy, the other forms of government, and then understanding the difference between direct and indirect democracy. Then we try to understand what is parliamentary democracy, how that is different from the presidential democracy, understanding the concept of separation of powers, checks and balances, what is a federal political system, what is a unitary political system, what is an independent judiciary, what is an integrated judiciary. And in that way, we have understood the other key aspects as well. And then now we have tried to understand a lot of important terms in polity, which is certain things which I'll repeatedly use again and again. So that whenever I use this word, you should be in a position to understand all these things. Okay. So now both for the online students as well as for the offline students, we have 5 minutes with me. If you have any questions from whatever we have discussed, you can raise your questions. Okay. You can just collect your doubts. In the meantime, I'll just go through the doubts of the online students and then I'll take up your doubts. Okay. So just give me a moment. Okay. Swapna, Vaishali, Ashish. Good afternoon to all of you. I'm just going through your comments. So let me see that if there's any question that I can, which is put against me. Okay, there's one question from Swapna. Sir, when there's a hung parliament, the president appoints one member as PM and gives him a period of time to get the majority seats. What are the next steps if will not get the majority of seats? So that's a question. Okay, very good question. So Swapna is asking, okay, sir, you told in case of hung parliament that the president can appoint anyone as a prime minister, whether they have the majority or not. But a certain time will be given for them to prove the majority. What will happen if that particular person is unable to prove the majority? Then in that particular case, there is no other way. Then the Lok Sabha has to be dissolved. The president will dissolve the Lok Sabha. If nobody is able to form the government with majority, then we have to go for a re-election. Then the Election Commission of India has to again conduct the re-election. Okay, that's the way it happens. But however you try to understand, whoever is appointed as a prime minister and the other council of ministers, they will continue to exist. But they will continue to exist as a caretaker government. They will not have the real powers. They are called as caretaker government. But in the meantime, the Lok Sabha will be dissolved and then the new elections will happen. And in the new elections, whoever is forming the majority, they will be appointed as the prime minister and then the other council of ministers. So this is how it happens. Okay, Abhishek, NHRC is what, statutory or constitutional body? NHRC is a statutory body. There's a Human Rights Act, which is passed by the parliament. So based on the Human Rights Act, this NHRC is established today. It's a statutory body. All right. So any questions from the offline students? Please, if you have any questions, please ask me, and also the online students. If you have any questions, you can just put it across. Okay, so there's a question from Path. Why is right to property called as a constitution? Why is right to property called a constitutional body or constitutional right? It should be constitutional right. Why it is called as a constitutional right? Because it is there in the constitution. It is guaranteed in the constitution, but not in the part 3 of the constitution. Because this right to property initially in part 3 of the constitution was later taken out and placed outside part 3 of the constitution. By which amendment it was placed outside part 3 of the constitution? Very good. 44th Constitutional Amendment Act, and under which article it has been placed? 300A. So it is still guaranteed in the constitution, but not as a fundamental right. So it still continues to be a right. But what right? Constitutional right. So I would request the online students to put your doubts in English. So I can understand, but I will not be able to completely comprehend if you put the language in Hindi. So, and that is also not going to help you in your examinations also. Okay, so you can ask me the doubts if you're orally asking me, but as far as possible, try to use the word English, because which can help you well in your interview. Although language has not much significance, as long as you're able to communicate whatever you know. But because I will not be able to comprehend certain words in Hindi, so it's better that whenever you ask me doubts, you can put it in complete English. So as far as I understand from Abhishek sir, Raj, separation and division of powers, parliamentary form of government and presidential form of government. Abhishek, you can just go and refer to the previous lectures. Our lectures are available to the students. Our previous one. Abhishek, you just go and look into the previous lecture, which we have already explained in detail. In case if there's any doubt after watching that, you can come and ask to me. All right. So let us move to the next topic. Statutory bodies may also be independent. It depends upon the law which is passed by the parliament to what extent they are making them independent. But going by the general understanding, the statutory bodies may not be as independent as that of the constitutional bodies. Okay, but it doesn't mean that they may not be independent. If the law is empowering them to be independent, they can also be independent. But then what is the problem? Even if the body is independent, tomorrow a new government can come and they can make changes in the law easily, and they can change the status of that body, which is unlikely to happen in case of a constitutional bodies, because it is extremely difficult to make changes in the constitution, because it requires a higher majority. There it requires only a simple majority. And that's exactly what you are going to understand right now. So please write down the next topic, that is types of majorities. Which one? There can be certain things which is quasi-judicial in nature. Constitutional bodies doesn't necessarily mean that they are quasi-judicial bodies. It depends upon the nature of the duty. So try to understand one thing. When I say it's a constitutional body, it is just answering the question by which it is established. And those constitutional bodies can also be quasi-judicial in nature, depending upon the nature of their functions. What is the power that is entrusted upon that body by the constitution? For example, here you can say the Election Commission of India is quasi-judicial in nature, because it can also entertain election disputes. The Comptroller and Auditor General, that is also having some element of quasi-judicial, but it is not explicitly given. But as Finance Commission is a quasi-judicial body. UPSC can also have certain quasi-judicial functions, but not quasi-judicial. Some kind of recommendations may be sought from UPSC. But NCSC, National Commission for Scheduled Caste, National Commission for Scheduled Tribe, National Commission for Backward Classes, they are all quasi-judicial in character. Okay, so try to understand constitutional status is based on where it is established, and whether it is quasi-judicial or not, it depends upon the functions that they perform and what is the power that they exercise. Okay, which all we'll discuss later, because it's a very big topic. Later we'll discuss all these bodies in detail. So it is not to entirely discuss, just to give a basic idea. The understanding is you should understand basically what is a constitutional body, what is a statutory body. Now write down the next topic, that is types of majorities. Types of majorities. That's exactly what you're going to discuss. Just give me a moment. Okay, let me see if you have done all the questions. Okay, I just want you to solve some of the questions here. Okay, and then we'll go to the next topic. Okay, try to solve these questions, and then I'll move to the next topic. Which of the following is true regarding the concept of judicial review? Yes, Aishwarya, what is your doubt? Which of the following is true regarding the concept of judicial review? Can someone tell me what is the answer? It is a power of the judiciary to question both the actions of the legislature and executive, violative of the provisions of the constitution. Is there any doubt with regard to, I would say, the option A? It is a power of the judiciary to look into the wisdom of the legislature. How many of you say that A can also be right? Or how many of you sure no, C is the answer? If C is the answer, why A is not the right answer? The executive is not mentioned. Okay, suppose if it is the power of the judiciary to look into the wisdom of the legislature and the executive. All those things are not the important thing. Whether it is executive, legislature, yes, the broadest definition is judicial review is a power. It is against both the legislature and the executive. But the key word here is whether it is in violation of the constitution or not. See, when you say of wisdom, wisdom means how one assess is accumulated knowledge and experience, how one assess something is right or wrong. The judiciary is not to see whether the legislature has done the right thing or wrong thing. It has to be seen in reference to certain other thing. See, a law can be bad. Try to understand. A law can be bad in the assessment of judiciary. But as long as that law is not violative of the constitution, it cannot be declared to be void. A law can be good in the assessment of the judiciary. But if it is in violation of the constitution, still it can be declared to be invalid. So what is judicial review? Based on which the judiciary can exercise its power. If it is only in violation of the constitution. So it is not looking into whether it is something is good or bad. It has to be seen in reference to the constitution. Understood? So this was an area where number of students have made mistakes. So I am making it very clear to all of you. It has to be strictly seen in reference to the constitution. For the students here, is it visible or something else? You can also change if you want. If you are comfortable, you can sit there. Okay, come to the next question. Which of the following is not a feature of written constitution? What is the answer? Which of the following is not a feature? Here it is asking that it is not a feature of written constitution. Codified mostly into a single document. Is it a feature? So it is not the answer. Organic document. Organic document means it can go for change. A matter, something which is organic, it can decompose and it can change from one form to another form. So, moreover, a written constitution, can a written constitution go for a change? Of course, it will go for a change. The Indian constitution has changed. The American constitution has changed. And it changes by way of an amendment. Okay. So, it is an organic document, flexible in nature. Is it true? Written document, written constitution. I said that the general principle of any written constitution is what? It is a rigid constitution because although it can go for a change, making changes is not easy. Okay. So it is not flexible in nature. So when you say it is flexible in nature, that is wrong. Okay. So what is the answer here? So the answer is option C. Yes. Whether it is flexible or it is whether rigid, it will go for a change. The only thing is the pace at which it will go for a change might vary depending upon whether it is organic. So you cannot say that just because it's a written constitution, making changes in that constitution, it cannot go for a change. It will go for a change because whenever a constitution is formulated for any country for that particular matter, try to understand it is done according to the political circumstances and the social and the economic factors at that point of time. And as and when the country progresses, as and when the environment and situation changes, the constitution has to accustom to those changes. So definitely it will be an organic document, be it a written constitution or an unwritten constitution. That is unique. But yes, it cannot go for a very rigorous change as in case of a unwritten constitution. Okay, so it is also an organic document, which is common for both the constitutions. Okay. See, you are talking about an exception. You are talking about an exception. So whenever we discuss some thesis or whenever we discuss some theory, we'll have to talk about the general rule, not about the exceptions. That is how we'll have to approach the questions also. We'll always discuss about what? The general rule, not the exception. The exception cannot become a general rule. Exceptions will always be there. But what we'll have to discuss and understand is about the general rule. Okay? Okay, come to the next question. Look into this particular question. Which of the following is true regarding the first past the post system? Try to answer this question. So what is that we have understood with regard to the first past the post system? The winning candidate should get more number of votes than all other candidates. That's the only thing. Is there a specific quota he has to get? Is there a specific majority he has to get? No. He has to get more number of votes than the other candidates. Very good. I think most of you have got all the answers, right? So we'll just move to the next topic. So write down the next thing, that is the types of majorities. So this is again, you should have a basic understanding of the types of majorities. So just give me a moment. Let me just open up the slide. Types of the majorities. Types of majorities. Write down the next topic. Types of majorities. Okay, there's a question from Abhishek. Why it is needed to amend the constitution if the statutory body can be simply made by an act like tribunals? I never said that to make changes to the statutory body, you'll have to amend the constitution. So that's a basic difference. To make any changes in the constitutional bodies, you need to amend the constitution. To make any changes in the statutory body, you'll have to amend the respective statute. You'll have to amend the respective law. So for example, tomorrow if you want to make any changes in the Reserve Bank of India, you don't have to amend the constitution. Where you have to amend? You have to amend the RBI Act. Suppose tomorrow you want to make any changes in, let us assume, the National Human Rights Commission. You don't have to amend the constitution because it is not mentioned in the constitution. You'll have to amend what? The National Human Rights Act. Suppose if you want to make any changes in the Election Commission of India, then you'll have to amend what? We'll have to amend the Constitution of India because it is established by the Constitution. So if it is a constitutional body, to make changes, you'll have to amend the Constitution. If it is a statutory body, then you'll have to amend the respective statute. You'll have to amend the respective law to make changes in that. Okay. So come to the next thing, that is the types of majority. Okay, we are discussing about, although the constitution is a written constitution, the constitution is also what? It is an organic document. When I say organic document, which is also one of the features of the Indian constitution, that the constitution can undergo a change. Has the constitution undergone change till this point of time? And we have seen that how many changes it have undergone till this point of time. 106 times the constitution has been amended since the commencement of the constitution. So many times the constitution has been amended. And who is the authority to amend the constitution? The parliament. The parliament is authority to amend the constitution. That means any changes that is likely to happen in the constitution, it can happen only by a constitutional amendment, which can happen in the parliament, provided the parliament approves this amendment with certain majority. So in a parliamentary democracy, try to understand, most of the decisions are taken by whom? In a parliamentary democracy, who is supposed to make laws? In a parliamentary democracy, who will make laws? The parliament has to make the law, and for making the law, of all the members in the parliament, they have to pass all these bills with certain majority. To amend the constitution, the members of the parliament, they have to pass it with certain majority. And in fact, what about the executive? We are talking about the executives. What are they? On the one hand, we are talking about the legislature, which is nothing but the legislative body, and then we are talking about the executives. Executives are like the ministers. I said that the prime minister and the council of ministers, they are the executives. From where do these executives come from? They also come from the legislature. So the executive is nothing but a council among the legislature. Certain members among the legislature will make up the executives. So whatever the decision mostly they take, or whatever the power that they exercise, like amending the law or amending the constitution, they all need to be passed with certain majorities in the parliament. Unless and until it is approved with certain majority in the parliament, nothing much cannot happen in our country, especially in a parliamentary democracy. But for different things, different types of majorities are required in the parliament. So for example, for amending the constitution, you need a separate majority. For passing an ordinary bill, you need a separate majority. For passing a no confidence motion, which you might have heard of somewhere, it requires a separate majority. So for different types of proposals to be taken up by the parliament or by the state legislature, it requires different types of majorities. But overall in the constitution, there are 4 types of majorities. I'm not going to explain you where these majorities are used, but in general, how many types of majorities are there in the constitution? 4 types of majorities, and these 4 types of majorities are used for various purposes. So what are those 4 types of majorities? Okay, so that is what we are going to understand. Write down the first type of majority. Simple majority. The first type of majority that you are going to understand is the simple majority. Write down a line about the simple majority. It is the majority of members. It is the majority of the members. It is the majority of the members present as well as voting. It is the majority of the members present as well as voting. Or in other words, if any proposal is brought in front of the parliament, or if any proposal is placed in the parliament, and if this proposal requires a simple majority, if any proposal is placed in front of the parliament, and if this proposal requires a simple majority, then it has to be passed. Then it has to be passed by a majority of members, present as well as voting. By a majority of members present as well as voting. By a majority of members present as well as voting. Okay, now let me give an example. Just tell me what is a simple majority. I say that this proposal requires a simple majority. And you tell me that how many members have to support this particular proposal. Let me see how many of you are understanding and getting this point. Suppose, let us assume, a proposal may be introduced. Suppose a bill, let us assume, an ordinary bill. This bill may be introduced either in the Lok Sabha or in the Rajya Sabha. Then it requires to be passed with simple majority in both the houses. Okay, now you tell me there are 543 membership, or Lok Sabha has got 543 membership. A bill is introduced in the Lok Sabha. What would be the simple majority? Go through the definition and tell me what is a simple majority that is required. That means unless and until these many members are supporting this bill, the bill is not to be passed in that particular house. So I'm giving the information. The total membership of Lok Sabha is 543. And then in the Lok Sabha, the bill is passed. It is placed. To the proposal to be passed, it requires the approval of, it requires what is called a simple majority. So how many members have to support this? That's my question. 272. How many of you agree with 272? What is your name? Tarun. So Tarun is saying it is 272. How many of you agree with Tarun? Agreed? Agreed? How many online students? So here in the class, Tarun is saying simple majority here would mean 272. So others are not agreeing with that? You don't agree or you agree? You don't agree. Okay, now tell me that, can anyone read that definition that I have given for simple majority? It is members present and voting. I'll ask a simple question to Tarun and others who have supported Tarun. I said that the total membership is 543. But it is only the total membership. May not be all the 543 members present on that given day. So I have not given the detail. I have not given the information as to how many are present on that day. I only said that a total membership. So what is your prejudiced thinking here is that all the 543 members are present. Suppose let us assume if the total number of students who have taken admissions in this particular class is 100. But not all the 100 students may be present on every day. So there can be some absence also. So you'll have to take that into consideration or not. I said the total membership is 543. But to calculate the majority, what it is saying, it is a majority of members present and voting. So Tarun's answer would be right only if all the 543 members are present. But I only said that the total membership is 543. So it does not mean that all the 543 members are present. So that means the information that I have given is insufficient to calculate the simple majority. Okay, now I am giving another information. On the day 500 members are present. So it is the total membership, but I am telling that 543 members are present. So how many members are present? 500. Now tell me what is the majority? 51? 251. What is your name? Yash. So Yash is saying 251. So how many of you agree with this? It is 251 is a simple majority. Online students, do you agree? I think most of the online students might agree now. I think most of you have to agree it right now. Is there anyone who doesn't agree? All of you agree? So Tarun is not agreeing now. Now, again, the answer is not right because the information that I have given is insufficient again. Because I only said that 500 members are present, but not all the 500 members may participate in the voting. So the information that I have given is insufficient to calculate what is called a simple majority. Okay, so do not make any assumptions because the definition clearly says what? It has to be present as well as voting, a majority of that. So now I'll tell you, out of this 500 members, let us assume 450 people are participating in voting. Present as well as voting. So how many people are participating in the elections actually, in the voting process? Not the elections, on the proposal they are voting. So now you tell me what is a simple majority. It is 226. So 226 is the simple majority here. (226) is the simple majority. So now you understand how you may make mistake. That means simple majority is the easiest majority to achieve. Suppose let us assume although the total membership is 543, on a given day let us assume only 200 people are present and voting. Then what would be the simple majority? 101. Even if 101 people approve that, then it is deemed to be passed. On a given day let us assume that only 150 people are present and voting. Then what is the majority that is required? 76. Although the total membership is 543, we are not concerned about the total membership. For calculating the simple majority, we are just concerned about only one thing. What? How many people are present and voting? And in that, do we have a majority? Is that more than 50% of present and voting? If it is more than 50% of present and voting, then the simple majority is achieved. Clear? But then the only thing that the Constitution restricts it, if there are less than 1/10 of the members in the House. So 543, so 1/10 member is roughly 55. If it is less than 1/10 of the members in the House, then the proposal cannot be taken up for voting. If it is there are more than 1/10 of the members present in the House, then you can take the proposal for voting. Suppose if there are 55 and more members, at any time it can be taken up for voting. And then if it is passed with simple majority, it is passed. So what is simple majority? Simple majority means it is the majority of members present and voting. Write down one example where this simple majority is used. So the idea right now in this class, when I say simple majority, you should be in a position to understand what is simple majority or how simple majority is calculated. The idea is not to make you understand where these majorities are used. That will come at the later stage. So have you understood how the simple majority is calculated? Okay, so on the other hand, let us take the example of Rajya Sabha. Now tell me in the Rajya Sabha, I am giving the total membership is 245. What is simple majority? The total membership is 245. So will you be able to calculate the simple majority with this information? The information is insufficient. So I say that out of this 245 members, let us assume 200 members are present. Now, can you calculate the simple majority? Now also it is not possible. Only when you know, okay, I'm saying that, okay, all the 200 members are present as well as voting. Then what would be simple majority? 101. So the information that is necessary to calculate simple majority. What we are concerned about is how many members are present as well as voting in the process. And in that you need to have a majority, and that's how you calculate what is called as simple majority. Okay, where and for what proposals these majorities are used? Okay, write down one or two examples. Say, for example, to pass all the ordinary bills, to pass all the ordinary bills, to pass all the ordinary bills, for all the, I said that depending upon the subject matter, there are different types of bills. To pass all the ordinary bills, what is the majority that is required? Simple majority. To elect the speaker in Lok Sabha, to elect the speaker, deputy speaker in the Lok Sabha, which majority is used? Simple majority. These are all some few examples. There are a lot of examples, but just know one or two examples. Okay, so to calculate the simple majority, if you just know the total membership, it is insufficient. And simple majority is the easiest majority that can be achieved. That's why the name simple majority. So now we understand in an unwritten constitution, I said why an unwritten constitution is flexible constitution. In an unwritten constitution, the majority that they are required to change anything in their constitution is simple majority. So it can be easily achieved. Write down the next majority, that is absolute majority. The second type of majority that they are going to achieve is the absolute majority. Absolute majority. So just write down a line as to what is absolute majority. It is a majority of, it is a majority of the total membership of the House. It is a majority of the total membership of the House. That's what is the absolute majority. It is a majority of the total membership of the House. Okay, now I'm giving this information. In Lok Sabha, the total membership is 543. And in Rajya Sabha, the total membership is 245. Will you be in a position to calculate the absolute majority? What is the absolute majority in case of Lok Sabha? The absolute majority in case of Lok Sabha is 272. And what is absolute majority in case of the Rajya Sabha? 123. So are you sure? How many of you are sure? Okay, this is the majority. It is right. There's no change in that. Okay, so try to understand in case of absolute majority, we are not concerned about how many are present and voting. Even if there are 500 members present, even if there are 400 members present, if you have to calculate absolute majority, it is always calculated on the basis of the total membership. Even if 272 members are only present, all the 270 members have to vote in favor. Then only it is deemed to be passed with absolute majority. So absolute majority is always a majority of the total membership of the House. We are not concerned as to how many are present and voting on the day. You need to have that absolute number. Okay, that is how the absolute majority is calculated. But what is very important is the absolute majority is not separately used anywhere. So it is not separately used anywhere in the Constitution, but it is used along with the special majority. Just write down a line. The absolute majority is not separately used in the Constitution. The absolute majority is not separately used in the Constitution, but it is used along with the special majority. It is used along with the special majority. All right, so but have you understood as to what is absolute majority? It is based on the total membership of the House. Now, the third type of majority that is given in the Constitution. So come to the third type of majority. Write down the third type of majority, that is effective majority. That is the effective majority. The third type of majority is what is called as the effective majority. So what do you understand by effective majority? So just write down a line and then I'll explain what is effective majority. It is a majority of the effective membership of the House. Online students, you also please write it down. It is the majority of the effective membership of the House. Vaishali, please wait. I'll complete the effective majority and then I'll take up your doubt. Okay. So what is effective majority? Effective majority means it's a majority of the effective membership of the House. Write down one more line. Effective majority is equal to, sorry, what did I say? It is the majority of the effective membership of the House. So effective majority is calculated from the effective membership. And then write down effective membership is equal to, so first to calculate the effective majority, we need to have effective membership. It's a majority of the effective membership. So effective membership is equal to total membership minus vacancies. Total membership minus vacancies. So how do you calculate the effective membership? Effective membership is equal to total membership minus vacancies. Say for example, first you need to have total membership to calculate what is called as effective membership. What is the total membership or the total capacity? Both are one and the same. What is the total capacity or the total membership of Lok Sabha? 543. Okay, now we have seen that the elections are happening to the Lok Sabha. This is 18th Lok Sabha. I already told that. 18th time the election to the Lok Sabha is happening. And when the election results are to be announced? On June 4th. And on June 4th, for 542 constituencies, it will be announced. Because for one constituency, already there is a winner. In Surat, there is already a winner in the Surat constituency. So for total, on June 4th, we'll have results for 543 constituencies. Okay, so the total membership is 543, but these members are likely to continue for the next 5 years. That is what the constitution says. But let us assume that after these 543 members were elected, the 18th Lok Sabha, after the result is announced, what within 6 months, unfortunately, some 5 members die. Is a possibility or not? They may die, they may get disqualified, they may submit their resignation. So all these would create vacancies in the Lok Sabha. Will it create vacancies in the Lok Sabha? And whenever the vacancies are created, it will take some time for the Election Commission of India to conduct what is called as a by-election. And then they fill the vacancies. But whenever a proposal is introduced in the House, there may be few vacancies till the time the vacancies are filled. So to calculate the effective membership, what you'll have to take into account? Total membership minus vacancies. Suppose when the proposal is introduced in the House and it requires an effective majority and there are 3 vacancies, let us assume. So what would be the effective membership? What would be the effective membership? 540 would be the effective membership. So once you know the effective membership and the proposal requires an effective majority, now calculate the effective majority. It would be 271. So to calculate the effective majority, first thing that you have to calculate is what? You'll have to calculate the effective membership when the proposal is introduced. And the majority of the effective membership is what is called as the effective majority. Is that clear to all of you? So you should know the total membership minus the vacancies at that point of time. And then you get to what is called as the effective membership. And the majority of the effective membership is what is called as effective majority. Is that clear? So write down one further line. The effective majority is used. So what are the areas where this effective majority is used? Effective majority is used in case of removal of speaker in Lok Sabha, deputy speaker in Lok Sabha, speaker Lok Sabha, deputy speaker Lok Sabha, deputy chairman Rajya Sabha, deputy chairman Rajya Sabha, deputy chairman Rajya Sabha, and also in case of speaker and deputy speaker in legislative assemblies, speaker and deputy speaker in legislative assemblies, chairman and deputy chairman in legislative councils, chairman, deputy chairman in case of legislative councils. In all these cases, there is use of what? Effective majority. I'm just repeating it again where it is used. It is used in case of removal, not in case of election. It is used in case of removal of speaker, deputy speaker in case of Lok Sabha, deputy chairman in case of Rajya Sabha. It is also used in case of speaker, deputy speaker in case of legislative assembly, and also in case of chairman, deputy chairman in case of the legislative council in the states. In addition to that, you can write it is also used in case of removal of vice president of India. So this majority is also used in case of removal of the vice president of India. Okay. Now come to the next type of majority. Okay, so before I move to the effective majority, the next type of majority, which is a special majority, there's one relation between effective majority and absolute majority. Under one circumstances, they both are the same. So can you anyone establish the relationship? When the vacancies are 0, then it is same as that of what is called as the absolute majority. Okay, so write down that note also. However, when the vacancies are 0, or when there are nil vacancies, however, when the vacancies are 0, when there are nil vacancies, the effective majority which will be similar to that of the effective majority is similar to that of absolute majority. The effective majority is similar to that of the absolute majority. Has anybody got any doubt with regard to the simple majority, absolute majority, and effective majority in understanding as to how to calculate that majority? Is it clear to all of you? Okay, just write down one more line as a separate statement. So the Constitution recognizes 4 types of majorities. What are the majorities? Did I say? Simple majority, absolute majority, effective majority, and special majority. So just write down one more line. So apart from the above types of majority, that is apart from the above mentioned majority, right? Apart from the above mentioned majority, that is apart from the above mentioned majority, that is the simple majority. Apart from the above mentioned majority, that is the simple majority, absolute majority, and effective majority, all other majorities are considered to be special majority. Apart from the above mentioned majority, that is the simple majority, absolute majority, and the effective majority, all other majority are considered to be what? They are considered to be special majority. However, there are different types of special majority. However, there are different types of special majority used for different purpose. However, there are different types of special majority used for different purpose. However, there are different types of majority used for different purpose, or different majority, different special majority prescribed by the Constitution for different purpose, or different types of special majority prescribed by the Constitution for different purpose. So here it is really important that I pass a moment to ensure that you have understood. If you have not understood, then it becomes a little difficult for us to proceed further. Is it clear to all of you? What is simple majority? Both the online as well as the offline students. Online students, any difficulty in understanding what is simple majority, what is absolute majority, what is effective majority? Is it clear? I need more response from the online students. Rishika has given, Swapna has given. What about the other students? I can see the faces of the offline students. So I think they are quite clear. What about the online students? Abhishek is saying no, he has not understood. What is your problem, Abhishek? Where is that you are lagging in clarity? Abhishek, whatever is your doubt, you can put in the chat box. Okay, I'll just attend to your doubt. For others, I'll just proceed to the next thing. So write down the next thing, that is the special majority. There's something which is called as the special majority. See, try to understand that there are different types of special majority. There are different types of special majority, but however, apart from all the three majorities, everything is considered to be what is called a special majority. Different types of special majority for different purpose. So the first type of special majority that I'm going to discuss, of course, I will not discuss all the special majority, but I'll give you an idea as to what the special majority is. So first, the special majority that is required in case of a constitutional amendment. So what does it mean by constitutional amendment? Constitutional amendment means this is the majority that is required in the parliament to make an amendment to the constitution. Whenever they're trying to make an amendment to the constitution, it has to be passed with special majority by both the houses. Both the Lok Sabha and the Rajya Sabha has to pass it with special majority. A constitutional amendment bill has to be passed with special majority. That is what we are trying to understand. But before we proceed further, you will have to understand that the constitutional amendment can be further divided majorly into two types. In fact, to amend the constitution, this power is given to whom? The parliament. And the parliament gets its power from the constitution. To be very specific, it is Article 368 of the constitution is giving this power to make a constitutional amendment to the parliament. And through this power, the parliament can amend the constitution. But to understand this further, the constitutional amendment can be further divided into two types. How they can be distinguished? Depending upon what has been amended in the constitution. I said how many articles are there in the constitution today? 467 articles, schedules, 25 parts, 12 schedules, all are there. So this amendment bill is trying to amend what? So whether it is trying to amend the federal provision or it is trying to amend a non-federal provision. Whether it is trying to amend a federal provision or whether it is trying to amend a non-federal provision. That's a basic understanding you should have. That means, or in other words, I'm just trying to put this question in your mind, that whenever a bill is introduced to amend the constitution, what is the subject matter of that bill? One is it is trying to amend the constitution. Within the bill, if you look into which article it is trying to amend, which provisions of the constitution it is trying to amend, and whether that provision is a federal provision or a non-federal provision. So who can tell me as to what is a federal provision? We already understood as to what is federalism. What is your understanding of the concept federalism? Federalism is something where there is a division of powers. Division of power between the center and the state. So now try to understand, when I say it is trying to amend the federal provision, that means by this amendment, it is trying to disturb the power balance between the center and the state. So federal means there is division of power. So any federal provision, if it is trying to amend, which is there in the constitution, it is trying to disturb the power balance between the center and the state. But it is amending the constitution, but it is not changing the power balance between the center and the state. Even after the amendment, there would be a status quo. Whatever is already there, it will be the same position. That would be the net result. But there is changes in the constitution. That means they are trying to amend the constitution, but they are trying to amend the non-federal provisions. Okay, I'm just repeating it again. So this is the important area. So any constitutional amendment bill that is introduced in the parliament, it can make changes to the federal provisions or it can propose changes to the non-federal provisions. Suppose if it is making changes to the non-federal provisions, after the amendment is made, still there is no change in the power balance between the center and the state. But suppose if they are amending the federal provisions, after the amendment is passed, it will change the power balance between the center and the state. It can be in favor of center, it can be in favor of state, it does not matter, but the power balance has been altered. So if the power balance has been altered, it has been shifted, then it is an amendment to which provision? Federal provision. If it is not shifted, if it is not changed, it still remains the same, then it is an amendment to the non-federal provision. For example, suppose if a bill is introduced to amend some fundamental rights. Say, for example, right to property was taken away by the 44th Constitutional Amendment Act. Right to education was inserted as Article 21A by the 86th Constitutional Amendment Act. Have they changed the power balance between the center and the state? By taking away some fundamental right or by inserting a new fundamental right, is it going to disturb the power balance between the center and the state? It is absolutely not going to change. Still, the power relation between the center and the state is the same. So amendment to such provisions of the Constitution, or what is called as amendment to the non-federal provisions. Example, fundamental rights. Amendment to Part 3 of the Constitution, or amendment to Part 4 of the Constitution, DPSP, etc. These are all considered to be what? Amendment to the non-federal provisions. But on the contrary, there can be an amendment to the federal provisions as well. Yes, there can be an amendment to the federal provisions as well. Say, for example, how many of you heard about Schedule 7 of the Constitution? Has anyone heard of the Schedule 7 of the Constitution? Just a brief idea I will give. What is the Schedule 7 of the Constitution? It is a Schedule 7 of the Constitution gives a list of items on which the Parliament can make law. It also gives a list of items on which the state legislature can make law. It also gives a list of items on which both the Parliament and the state legislature can make laws. So only on those areas the Parliament will be able to make law, whatever is mentioned in the what the Parliament can do. But suppose, let us assume tomorrow you transfer some items on which the state legislature can make law to an item where the Parliament can make law. So is it giving more power to the Parliament? Or when you transfer vice versa, you are transferring some items from on which the Parliament can make laws to the state legislature. Then also you are disturbing the power balance. So in that case, such an amendment would be considered to be amendment to the federal provisions. Okay. So this much you'll have to understand. Let me just repeat whatever I said again. So just try to follow it. So first we have understood the different types of majority. All of you please listen. First we have tried to understand the different types of majority. First we said simple majority, and then we have seen the absolute majority, and then we have seen the effective majority. So apart from all the three types of majority, the other majority would be considered to be what? It would be called as special majority. But there are different types of special majority under the Constitution used for different purpose. So one type of special majority is used for what? For making an amendment to the Constitution. And again, in case of making an amendment to the Constitution, we'll have to see whether that amendment is a federal provision or a non-federal provision. So what is a non-federal provision? That this amendment is not going to disturb the power balance between the center and the state. And what is an amendment to the federal provision? This amendment is going to disturb the power balance between the center and the state. In both the cases, the majority that is required is special majority, but however, there is a difference. In both the cases, what is the majority that is required? Special majority, but with a difference. So now, first let us try to understand the special majority in case of amendment to the federal provisions. Okay, so we have seen what is a constitutional amendment means. It is making changes in the Constitution. And then this can be further divided into what? Amendment to the federal and non-federal provisions. In both the cases, what is the majority that is required? Special majority. So first let us try to understand what is a special majority in case of non-federal provisions. So write down the condition that it is required. Just write down the condition and then I'll explain it. What is a special majority? The special majority here is not less than 2/3 of the members present and voting plus 2 absolute majority. Just write it down and then I'll explain this. So try to understand if at all the amendment bill is trying to amend the non-federal provisions, it requires special majority. And how do you calculate the special majority? It has to satisfy both these conditions. That is not less than 2/3 of the members present and voting, and also it should satisfy the condition of absolute majority. So only with examples you will understand what the special majority is. So whenever the bill is introduced, try to understand if this bill, if it is introduced in the Lok Sabha, so it has to be passed with special majority in the Lok Sabha separately, and then when it is passed with special majority in the Lok Sabha, then it will be sent where? It will be sent to the Rajya Sabha. There also it has to be passed with special majority. So once it is passed with special majority in both the houses, then it will be sent for the president assent. So that is a separate case. We are not concerned about that. What is the process? We are just trying to understand what the special majority is. But it has to be passed with special majority separately in both the houses, for which two conditions has to satisfy. Not less than 2/3 of the members present and voting. So what does it mean by not less than 2/3 of the members present and voting? Suppose let us assume the bill is introduced in the Lok Sabha. Where it is introduced? Lok Sabha. We know what is the total membership of Lok Sabha? 543. But we are concerned about what? We are concerned about present and voting. We are not concerned about the total membership. So what is the information we need to have when the bill is introduced in the Lok Sabha is how many members are present and voting. What is the information we need to have? How many members are present and voting. So let us assume that 450 members are present and voting. How many are present and voting? 450 members. So out of the present and voting, how many people have to support this proposal? Not less than 2/3 of the members present and voting. So when I say not less than 2/3 of the members present and voting, it can be more than that, but it should not be less than that. So the least number would be what in this case? In this case, not less than 2/3 of the members present and voting means how many members? At least 300. At least 300 members have to favor the constitutional amendment bill. It can be more than 300, but the minimum should be what? Minimum 300. So the first condition, is it satisfying if 300 members are voting in favor? Now you'll have to see whether this not less than 2/3 of the members present and voting, these members who are favoring it, is it also satisfying the condition of absolute majority of the House? What would be the absolute majority of the House? 272. So whether this number 300, is it equal or more than the absolute majority? It is equal or more than. So in that case, both the conditions are satisfied. So the special majority requires what? The special majority requires both these conditions to be satisfied. Not less than 2/3 of the members present and voting, and it should also satisfy the condition of absolute majority in case of Lok Sabha. What would be the absolute majority in case of Lok Sabha? 272. And this 300 is more than 272. Let me give another condition contrary. Now tell me. Again, let us take the example of Lok Sabha. So this is case 1, where the case 1, the first condition, not less than 2/3 of the members present and voting, 300, and this 300 is also satisfying the condition of absolute majority. Now let us take the case 2. Case 2. Let us assume the total majority. What is the total membership of the House? 543. But let us assume on a given day only 300 members are present and voting. What is present and voting? 300 members are present and voting. So out of this, let us assume 200 people are voting in favor. So 200 people are voting in favor. How many in favor? 200 in favor. Is it satisfying the first condition? Not less than 2/3 of the members present and voting. Is it satisfying the first condition? Is it satisfying this condition? It is satisfying the first condition, because not less than 2/3 of the members present and voting means out of 300 members present and voting, it should be 200 members. The first condition is satisfied. But is it satisfying the second condition of absolute majority? Whether this members present and voting, is it satisfying the absolute majority? It is not crossing 272 or equal to 272. So in this case, yes, there is a special majority, but in this case, no special majority. So special majority means what? It has to satisfy both the conditions. Is it clear to all of you? Is it clear to all of you? So this is basically what is the special majority. Now tell me, in simple majority, all that you need is only one majority. What? Majority of the members present and voting. So getting special majority in the parliament is easy, or getting simple majority in the parliament is easy? Simple majority is easy. That's why to amend the constitution, you will have to use what? You will have to use the special majority. So it is not easy to achieve this. That too in both the houses, not only in the Lok Sabha, but also in the Rajya Sabha. Let us assume that the government is having the majority in the Lok Sabha. That too, they do not have the special majority. So they also need the help of the opposition parties. So it is extremely difficult to make a constitutional amendment. But this majority in case of what? In case of non-federal provisions. So this majority is separately required in both the houses. Once it is passed with special majority in the Lok Sabha, in the Rajya Sabha also it requires a special majority. Have you understood the special majority? No. Now the second thing is, what if there is an amendment in case of a federal provision? So what do you understand by federal provision? That this amendment is going to disturb the power balance between the center and the states. So in this case, a little bit of extra is required. So here write down the special majority. So here, what is a special majority? How do you calculate the special majority? So here, three conditions has to be satisfied. One, not less than 2/3 of members present and voting. Plus 2, the absolute majority. Same way, as you would calculate there, the same way you will calculate these two majorities. So it should not be not less than 2/3 of the members present and voting in the Lok Sabha, then in the Rajya Sabha, or in the Rajya Sabha, then in the Lok Sabha. So here, after it is passed with special majority in both the houses, it goes for the president assent. But here it will not go for the president assent. Then after this, it also requires ratification by not less than half of the state legislature. All the three conditions has to be satisfied. It requires ratification by not less than half of the state legislature. Now try to understand, it comes from the name of the amendment itself, because it is amending a federal provision. A federal provision means what? It is trying to disturb the power balance between the center and the state. So once it is passed with special majority in both the houses, this does not directly go to the president, but rather where it is sent. This bill is sent to the various state legislature in our country. So today, how many state legislatures are there in our country? How many states do we have? 28. So it will be sent to the 28 state legislature. It will be sent to all the 28 state legislatures, where the state legislatures have to approve. How many state legislatures have to approve? Ratification means they have to approve. This proposal will be placed in the legislative assemblies of the states, and the legislative assemblies have to approve them. So it is saying ratification by not less than half of the state legislature. Out of 24, what would be not less than half of the state? Not less than half of 28. Minimum 14 states. It can be more than 14 states, but minimum 14 state legislatures have to approve this. Again, try to understand, UPSC can easily confuse you saying more than half of the state legislature. It is not saying more than half. There's a difference between more than half and not less than half. Out of 28, not less than half would be 14. Out of 28, more than half would be what? 15. So the constitution is saying not less than half of the state legislatures have to ratify. Now, similar to that of the ratification, just listen to me. Not less than half of the state legislatures have to ratify. So the state legislative assembly members, they should also vote. Ratification means they have to vote. They should also pass it with some majority. So what is the majority with which? So total number of state is not less than half of the state legislature. Each and every state legislatures have to ratify that with some majority. So what is the majority with which they have to ratify? They have to ratify with simple majority. The state legislatures have to ratify with what majority? Simple majority. So try to understand this. So in case of a constitutional amendment, the majority that is required is special majority in the parliament. And this special majority, how it is calculated? It depends upon whether it is amending the federal provision or it is amending the non-federal provision. So if it is amending the federal provision, then it has to satisfy two conditions, not less than 2/3 of the members present and voting plus absolute majority. If it is amending the federal provisions, then it is not less than 2/3 of the members present and voting plus absolute majority. plus it shall also be ratified by not less than how many state legislature? 14 state legislature, or not less than half of the state legislature presently. Tomorrow, let us assume there are 29 states, because the states can be increased or decreased. Tomorrow, if there are 29 states, then how many state legislatures have to ratify? 15. Okay, because it is not less than half. And then once the state legislature ratify, half of the state legislatures themselves have to ratify with what majority? By simple majority. Once all these things done, then it will be sent to the president assent. So this is how you calculate the special majority. Now, whether making this amendment is difficult, non-federal provision amendment is difficult, or this amendment is difficult? Federal provision is difficult, because the state should also accept to that. Why? What is the logic why the state has to accept to that? Because it is trying to change the balance or power of the state. So state should also give the ratification. Then only it can go to the president assent. So is the special majority clear? So this is one type of special majority, which is related to amending the constitution. And with regard to amending the constitution, federal provision or non-federal provision, you have to see that. Write down the second type of special majority. UTs are not included in this. It is only the states. UTs are not in a federal relationship with the union government. UTs are under the control of the President of India. So I clearly said the word states. So state means there are only 28 states. Okay, so write down the next type of special majority. The second type of special majority is with regard to the removal of the president or the impeachment of the president. Impeachment means removal of the president. In the constitution, there is a special majority that is required for the removal of the president as well. For removing the president, what we need? We need a special majority. And for that also, a special majority is required. But here the special majority is a little different. Because I said that apart from simple majority, effective majority and absolute majority, all the majority are called as what? Special majority. But different types of special majority for different purpose. So here, what is a special majority? Write down. So here the special majority is majority of not less than of the total membership of the House. A majority of not less than 2/3 of the total membership of the House. A majority of not less than 2/3 of the total membership of the House, which has to be separately passed in both Lok Sabha as well as Rajya Sabha. So this proposal has to be passed with this majority in both the houses, both in the Lok Sabha as well as in the Rajya Sabha. So how do we calculate this majority? Majority of not less than 2/3 of the total membership of the House. So what would be the majority here when I use the word majority of the total membership of the House, not less than 2/3 of the total membership of the House. So what would be the majority that is required in case of Lok Sabha? We know what is the total membership in case of Lok Sabha. What is the total membership? 543 multiplied by 2/3. Majority of not less than 2/3 of the total membership of the House. What is the majority in case of Rajya Sabha? 245 into 2/3. So if you calculate this, can anyone tell me the majority here? If you calculate this, it would be what? Rounded off to the nearest figure. Can anyone calculate and tell me? That is 543 multiplied by 2/3. Now just calculate it and tell me exact decimal figures also. If you just calculate through your mobile and tell me which is, I think here it is 543 into 2 It should be 1086 divided by 3. It's a whole number here. $362. Okay, so here it is 362. And in case of Rajya Sabha, 163.33. So it would be 163 in this case. Okay, so unless and until these many members support, because it is not less than 2/3 of the total membership of the House, we are not concerned about how many are present and voting. Unless and until these many members support in the Lok Sabha, minimum, it can be more than that, support the removal of the president cannot be removed. So if these many members support the removal of the president, then the president may be removed from the office. Has any president been removed in our country through the impeachment process? Not even a single president has been removed till this point of time. Leave the removal. The process itself has not been initiated till this point of time, although there is a provision in the constitution. So this is one type of special majority. And of course, apart from this, there are also certain other types of special majority. I'll let you know all those things at the later stages. But all that you'll have to remember is that under the Constitution of India, how many majorities are recognized? 4 types of majorities: simple, absolute, effective, and special majority. So henceforth in the class, I'll say that, okay, this process requires a simple majority. You should be in a position to comprehend as to how to calculate the simple majority. When I say this requires effective majority, you should be in a position to comprehend how to calculate the effective majority. When I say absolute majority, you should be in a position to calculate that. When I say special majority, I'll say you what type of special majority. You should be in a position to understand that. When I say special majority to amend the constitution, federal provision, you should know what is a special majority. Non-federal provision, you should know what is a special majority. When I say special majority for the removal of the president, you should know what is a special majority. Is it clear to all of you? So all these majorities are required in the parliament. Okay. So is it clear to all of you? The types of majorities? It would be 163, because if it is 5 or more than that, then it will go to the next number. If it is less than that, it will be the previous number. Okay. So this is the majority that you should have. Online students, is it clear to all of you? Any doubts in calculating this majority? Swapna, Rishika, any other students, is it clear to all of you? The different types of majorities? So now we are moving to the next part. We are just one step away from going to the preamble to the Constitution of India. So we have to understand something which is called as a historical underpinning. There is a syllabus, there's a topic in your syllabus which is called as the historical underpinning. I'm not going to discuss the historical underpinning right now. I'll just discuss the Constituent Assembly and then I'll come back to the historical underpinning. But I'll just give you a background of what this historical underpinning is all about. Historical underpinnings. So what do you understand by historical underpinnings? This is a word that is given in your main syllabus. Can anyone tell me what do you understand by historical underpinnings in the context of course, the Indian Constitution? The watershed moments probably that has led to the development of the Indian Constitution. Okay, so many of you might come across this particular term that the Constitution of India is a borrowed constitution. But wouldn't it be completely true to say it's a borrowed constitution? In fact, 200 years of constitutional development has happened in our country. When the Britishers ruled India, there was some rule of law, or I would say that there was some law based on which the country was governed. And then what was the last law that was passed by the British Parliament to govern India? So the Indian Independence Act 1947 was not the last law that was passed by the British Parliament to govern India. The Indian Independence Act, the only thing is it gave independence to India. So based on that, we never governed India. The Indian Independence Act is based on which independence was given. So before that, there was an act which was called as the Government of India Act 1935. And in fact, even after independence, I already said in the last class, even after independence, India continued to be governed under the Indian Government of India Act 1935 till the time we had our own constitution. So what culminated, what resulted in this Government of India Act 1935 is what is called as a historical underpinnings. In fact, the Britishers started regulating the East India Company. You might have heard of the word East India Company, because you know that the Britishers who came to India, they came to India not as rulers, they came to India as traders. As far as I think the evidence is there, they came somewhere in 1600, starting 17th century or late 16th century. And they initially came as traders, they established trading settlements in our country, and they started to settle down in three major areas. Do you know what are the areas that they started settling in initially? They initially started in places like where they developed cities and all those things, which is also called as a presidencies. They started to settle down in Bombay, Madras, and Kolkata. So these are the three major settlement areas as it developed as a presidency. I'm not talking about where they initially came, but how they developed as a city and all those things. That is not very relevant to the subject of polity. Okay, I'm just talking about how broadly as a settlement they started developing. So they settled in all these three major presidencies. And then they started trading with India also. And then that is when they started some kind of political development that can happen in our country. Initially, they just settled as traders. And then in starting 18th century, Aurangzeb died. And that is when they thought that there is some political vacuum in our country. And they had some kind of political involvement in India. And they started politically controlling India after the first battle that they won, is what is called as the Battle of Plassey. Does anyone know when the Battle of Plassey came into? When was it? 1757. So 1757, there was Battle of Plassey. Battle of Plassey, where they defeated the Nawab of Bengal. Who was the Nawab of Bengal at that point of time? Siraj-ud-Dowla. Somebody have a history background, they may know it, but others you will read it in the history. Okay. So 1757, they defeated and they got more interest in having political control over India. And then again, within few years, they enter into another battle, which is called as Battle of Buxar. Which is, I think, the present place where Bihar is, Battle of Buxar. And they defeated the combined forces of combined forces of Nawab of Awadh, which is the region of, I think, eastern Uttar Pradesh today. Nawab of Awadh, Nawab of Bengal, and Shah Alam. So all the three people will be defeated. And then that is when they got what is called as Diwani rights. So try to understand that the Britishers who came to India, they came as what? They came as traders. It is not only they came, there were a lot of other Western countries also who came into India. But they become so prominent, they established settlements, they started carrying out trade with India. And when they saw a political vacuum, they enter into trade. They enter into battle, they won the battle. And after the Battle of Buxar, they got what is called as Diwani rights. So all these things are nowhere related to your constitution. I'm just trying to give a background, okay? So maybe you'll read it in a lot of detail, maybe in your history. I'm just trying to give a context, to set some context. What do you mean by these Diwani rights? Right to collect land revenues and other taxes. Okay, so they were given some kind of right to collect taxes. So right to collect taxes. But all these time when they came, if you see that when the Britishers came to India, the Britishers came to India because they were given some kind of charter by the British Crown. That means the British Crown has authorized them to carry out trade in India, and that company was what is called as the East India Company. It was the East India Company which was given the rights. And only these people who came to India as traders, and they started doing all these things. And in fact, the East India Company was given a monopoly in the British sites, and they came out and they started doing trade in India. And what has happened over a period of time is once they got this Diwani rights, they were empowered so much and they were some kind of maladministration. The East India Company engaged in some kind of maladministration in the sense that there was a lot of corruption within the East India Company. And that is when, see, try to understand, the East India Company is getting the rights from where? It is getting the rights from the British Crown. But they are doing a lot of maladministration in terms of collecting taxes and engaging a lot of corrupt activities. And that is when the British Parliament passed the first act, which is called as the Regulating Act. How many of you heard about this? Regulating Act of 1773. So this Regulating Act of 1773 was the first law that was passed by the British Parliament to regulate the affairs of what? Regulate the affairs of East India Company in India. And starting this Regulating Act of 1773, it continued for some time. They brought in a lot of laws, which I'll subsequently discuss. So it continued till the revolt of 1857. So starting the Regulating Act of 1773 till the revolt of 1857, it was what is called as the company rule in India. Although India was a subject of British Crown, but the Crown was not directly involved in the administration. On behalf of the Crown, who was carrying out the administration in India? It was the East India Company. And a lot of laws was brought in, which we'll subsequently discuss under this. And try to understand, when the company was ruling in India, a lot of laws was passed so that they can control the company. This entire era was what is called as era of centralization. What do you understand by centralization? That the power was completely centralized. They were trying to centralize more and more. But then later they understood that this centralization is one of the major reasons for their failure, which was led to what is called as revolt of 1857. You might have heard of the revolt of 1857, where the Sipahi Mutiny, or which is also called as the first war of Indian independence. They thought that they were not able to maintain properly or have a proper administrative control over India because of too much of centralization. Now then started an era of what is called as decentralization. Henceforward, they have gone for more. The British have gone for more of decentralization, starting the Act of 1858. Act of 1858, which is also called as the Act of Good Governance in India. Act of 1858. So what is the change that has happened by this Act of 1858 is till 1857, who was administering the British India? The East India Company, but on behalf of the Crown. So then the British Parliament thought no longer the East India Company will administer. The British India will be directly administered by the British government and not by the East India Company. So that was by the Act of 1858. So starting 1858, they went on till what is called as the Indian Independence Act. Act 1947. So by this, there were a lot of other legislations within this. So this Indian Independence Act 1947 finally gave independence to India. But then if you see an act that was before the Indian Independence Act, that is nothing but the Government of India Act 1935. That means starting the Act of 1858 till the Government of India Act 1935, a number of constitutional developments have happened gradually in our country, that is in the British India. And they also have a lot of impact in the Constituent Assembly. And not only in the Constituent Assembly, today they also have a lot of impact in the present constitution that we have. So as a student who is also knowing about the Indian Constitution, UPSC probably thought you should have some basic idea as to what kind of constitutional development has happened. So that's basically what is covered under this particular topic of what is called as historical underpinning. So do you understand what is historical underpinning? So to summarize this historical underpinning, I would say, so these are the things that you should be aware of. You can make a note of this, but tomorrow I'll discuss this. What will be covered under this historical underpinnings? So we'll be discussing about both the things. One is here the company rule, brief developments that has happened. Company rule, right from 1773 to 1857. And then you have the Crown rule from 1858 till 1947. So what are the major developments that has happened? You can just make a note of it. It started with the Regulating Act. Act 1773. Then you have Act of Settlement or Amending Act. This Act of Settlement is also called as Amending Act, 1981. And then you have Act of 1786. Okay, 1773, 1781. Okay, and before the Act of 1786, you have Pitt's India Act. When is the Pitt's India Act? 1784. You have the Pitt's India Act. Okay, I'll just make a correction here. You have the Pitt's India Act 1784, and then you have Act of 1786, and then you have the Charter Acts, which is from 1793. Every 20 years there was a Charter Act. 1793, 1813, 1833, and 1853. These are the developments that has happened during the company rule. Okay, I'm just repeating it again. Regulating Act 1773, Act of Settlement or Amending Act 1781. 1781, Pitt's India Act 1784, Act of 1786, and then Charter Acts. Charter Acts means this is basically the right that was given to the East India Company by the British Crown, and they kept on extending these rights every 20 years with certain changes. Okay, so these developments have happened during the company rule, which we will subsequently discuss. And then here comes the Crown Rule. So the Crown Rule has started from the Act of 1858, which is also called as Act of Good Government in India. Act of 1858. And then I would say Indian Councils Act. Indian Councils Act 1861, and 1909. So there were three Councils Act. One passed in 1861, and then 1892 and 1909. And then two Government of India Act. Government of India Act, one is 1919 and 1935. Government of India Act 1919 and 1935. And finally, there was an Indian Independence Act. Indian Independence Act. So we'll briefly touch upon all these acts under this particular topic of what is called as historical underpinning. Okay. So what is more important for us is what happened during the Crown Rule. This is when a lot of developments have happened in the council. What do you understand by the Indian Council? The word Indian Council is more or less equivalent to that of what today? Today, the legislative body we have. Although that the council also had an executive council, but most importantly, the developments that has happened to the legislative council. So we'll try to understand all those things as we'll proceed further. But before I take up all these things, I wanted to take your attention to one specific area, which is called as the Constituent Assembly. Okay. The Constituent Assembly. So try to understand naturally what has happened. The Britishers came to India, then there was almost 100 years, 150 years they were just a traders, 100 years there was a company rule, then for the next 100 years there was a crown rule. And when the crown rule was happening, actually a lot of constitutional developments were happening. Constitutional developments were happening means we are moving towards some kind of democratic means of government. And when these constitutional governments or developments were happening, there at one point of time there was a demand for what is called as self-rule. You know that the Indian National Congress was established and gradually there was demand for self-rule. And what was a very basic for a self-rule? We need to have our own set of laws. The Indians should govern India. And for the Indians to govern the India, there is a need for what is called as a constitution, which is basically to be drafted by the Indians. And for that particular purpose, what we need to have a constant assembly to draft the constitution. And that demand was indirectly put forward by Mahatma Gandhi in 1922. So when at all the demand came that India should be governed by the Indians, it was put forward by Mahatma Gandhi ji in 1922. He did not directly use the word Constituent Assembly, but then the idea of having the own constitution and all those things was put forward by him in 1922. And then gradually this idea was taken up by the Indian National Congress. Indian National Congress officially made it its that India should be governed by Indians in 1934. In 1934 session in the Indian National Congress, it made the official objective of the Congress is to have and establish what is called as a Constituent Assembly. But then starting 1934 also much did not happen. But you know that in 1939 there was some significant event that has happened in the world history. Does anyone know what is the significance of 1939 in the world history? World War II started. So when World War II started, the Britishers are looking for the support of the Indians in the Second World War. And for that support, the Indians were demanding that they need to have a Constituent Assembly. So the Britishers came out with something which is called as August Offer in 1940. Does anyone know what is this August Offer in 1940? That the Britishers said officially, okay, you cooperate with us in helping and supporting in the war. And after the war is over, we will establish a Constituent Assembly. So for the first time, the Britishers recognized, okay, we'll allow you to have a Constituent Assembly was through the August Offer. Okay, and then further they elaborated, which was called as the Cripps Mission. But the Indians were not very happy about the August Offer. Then in 1942, there came something which is called as Cripps Mission. How many of you heard about this Cripps Mission? Because the Indians were not happy with this August Offer because they said that primarily it will be by the Indians. But the India was demanding it should be solely by the Indians. Because when we draft the constitution, it should be by the Indians, not primarily by the Indians. So there was some conflict which the Britishers did not accept. But then in 1942, a mission was sent to India, which came to be what is called as Cripps Mission. Has anyone heard of this Cripps Mission? What is the reason why the Cripps Mission was sent to India? Because in 1942, the situation was so dangerous that the Japanese were almost at the doorsteps of India, in the eastern part of India, to be very specific, in the northeastern part. And it immediately required the support of the Indian army. So the Britishers sent a mission in the name of what is called as Cripps Mission. Stafford Cripps was sent to India to seek the Indian cooperation in the World War. And they said that it will be solely, so once the war is over, there will be a Constituent Assembly, it will be solely done by the Indians. Then India supported the war. And then the World War came to an end. You know that it came to an end in 1945. When the World War came to an end in 1945, there was also change in the British. There was a leadership change in Britain. The Labour Party came to power, 1945. And if you look into the history, the Labour Party was so empathetic towards the Indian independence. And then they decided, okay, sooner or later we'll give independence to India. But before we will give independence to India, there has to be some mechanism for responsible transfer of power. Because India till this point of time was ruled by whom? By the Britishers. And they have decided, okay, we'll give the independence. Once independence is given, there has to be some responsible government that has to be instilled. Otherwise, how they will be able to rule themselves? To make this responsible transfer of power to happen, the first thing that should be taken into consideration is that whether there's a constitution that they have to govern themselves once they become independent. And before the constitution, what is a prior thing is that they need to have a Constituent Assembly. And once they've decided, okay, we'll give independence, this Labour Party has sent one mission to India. That is the Cabinet Mission. So this Cabinet Mission was sent to India in 1946. And what is the mission of this particular Cabinet Mission? 3 members were sent to India as a part of this Cabinet Mission. And what was their mission? To hold consultation with the various political parties in India. Who are the major political parties in India at that point of time? Indian National Congress and the Muslim League. So to hold consultation and to devise a scheme as to how to establish the Constituent Assembly. So this is very important. If a question comes in the examination, what is the scheme based on which the Constituent Assembly of India was established? What was the scheme? It was based on, or which plan? It was based on the Cabinet Mission plan. So you can also note down the members. Sometimes they may ask in the examination. So there are 3 members who were sent as a part of this Cabinet Mission. Stafford Cripps, Sir Pethick Lawrence, and I think A.B. Alexander. So these were the 3 members who were sent to India. And why it is called as cabinet mission? Now all these 3 people, they were ministers in the British cabinet. A cabinet mission was sent, and with an intention of what? To hold discussions with the 2 major parties in India, British India, the Indian National Congress and the Muslim League, and to devise a mechanism to establish the Constituent Assembly of India. And it was not a very easy task for them to devise a mechanism to establish the Constituent Assembly for India, because then the Muslim League came out with an idea of what is called as two-nation theory. They are not okay with one single Constituent Assembly because they wanted a separate state of Pakistan and a separate Constituent Assembly for them. But then this cabinet mission has rejected the idea of what is called as two-nation theory for their own interest. If you look into history, it was not for the Indian interest, it is for their own interest, because initially they thought that India would always remain as a dominion, and then unified India is always a support to Britain in the future. So anyways, they rejected the idea of two-nation theory, and then they came out with an idea of what is called as the Constituent Assembly. So the Constituent Assembly of India was established based on which plan? Based on the cabinet mission plan. That's the first thing that you have to understand. And then they devised the scheme for this Constituent Assembly. So this is very important. The scheme of the Constituent Assembly in India. So almost in June 1946, they decided as to what should be the scheme of this Constituent Assembly. They held discussion, and ultimately both the Indian National Congress and the Muslim League, they accepted, okay, we'll have a Constituent Assembly. And they also came out with a formula as to how to constitute this Constituent Assembly. In fact, even the cabinet mission, they wanted to have a Constituent Assembly where the people are directly elected by adult franchise. But it was not possible because they wanted to bring this body as soon as possible. If you go for direct election, it becomes impossible. So they came out with an idea of what is called as indirect election. So how were the members elected to the Constituent Assembly? Indirect election. There was no direct election. So what is the scheme? So their idea is the Constituent Assembly will have representation from both provinces and princely states. The representation in the Constituent Assembly will be from where? From both the provinces and the princely states. If you have this little bit of idea, you will understand that the British India were territorially, there are 2 types of entities. One is what is called as the British provinces, other is what is called as the princely states. Can anyone tell me what is the difference between the British provinces and the princely states? The princely states were submitted to the Britishers, but they are largely an internally autonomy. There was a lot of internal autonomy. They are largely ruled by the respective rulers in these areas. But the provinces were, they had an elected government at that point of time. So to put it in another way, these British provinces are similar to that of what? Today, states in our country. Today we have 28 states. At that point of time, there were 11 provinces in India. 11 provinces, and in all these 11 provinces, there was an elected government. There was a provincial legislature. There was an elected government. So the representation in the Constituent Assembly will be both from the provinces as well as from the princely states. So princely states are like the, say for example, the Jammu and Kashmir, Junahar, they were all princely states. They were all ruled by the rulers with a lot of autonomy. And they decided there will be total 296 plus 93 seats. So that means they have devised a mechanism that is the Constituent Assembly will have overall how many seats? If you add these 2 things, it will have 389 seats. Out of the 389 seats, this is the Constituent Assembly. Out of these 389 seats, 296 seats will be given to what? Will be given to the provinces. And 93 seats will be given to the princely states. And further, there was a bifurcation. Out of this 296 seats, it was 292 plus 4. There were 11 provinces which will get 292 seats, and there were 4 commissioner provinces. There are provinces like Delhi, there are provinces like Coorg, Baluchistan. So certain other provinces. There were 4 provinces. There was no elected government. They were commissioner provinces. Directly, a person was appointed as a commissioner by the British government, and he ruled out and he carried out the administration. So overall, there will be 292 plus 4. Whereas in case of provinces, it was through elections. Elections has been indirect elections. So from the provinces, how they will come? It was through indirect elections. And from the princely states, how the members are to be nominated here? It was through consultation. So it was through a consultation process. Basically, it was a nomination. The ruler of the princely state will nominate the members representing the princely states. Okay, now the next question is, if we talk of indirect election, so who will have the right to vote to elect the members to the Constituent Assembly? It was through an indirect election. I said that in all these 11 provinces, there was a legislative assembly, which is called as a provincial legislative assembly. The elections to this provincial legislative assembly happened in 1948. Just before a year, the elections to the legislative assembly happened. I am repeating it again. Each and every province had a provincial legislative assembly. Provincial legislative assembly means a body similar to that of the state legislative assembly today. So they had elected members. Those members will vote and elect the members to the Constituent Assembly. Okay, only those people will have the right to vote. Okay, so who are electing these members from the provinces? Provincial legislative body, or I would say provincial legislative assembly. These provincial legislative assembly members will elect the members from the provinces, and from the princely states it was by what? It was by nomination. So in this way they devised this. The members of the provincial legislative assembly, how they were elected in 1945? They were elected by direct election. They were elected by direct election because the government of India Act 1935 already allowed for direct election. But limited adult franchise or universal adult franchise, the respective provinces, it was through limited adult franchise. There was limited adult franchise. What do you mean by limited adult franchise? Only very few people in the provinces had the right to vote. It is not that similar to that of the Indian Constitution today that everybody will have the right to vote. It was just a limited adult franchise. Voting rights was given based on their education, based on property, based on their status. Around 20-25% of the people were given the right to vote. So they elected the members to the Provincial Legislative Assembly. And from the Provincial Legislative Assembly, whoever is in that particular province, they were only allowed to vote and to select the members to the Constituent Assembly. So in this way, overall, this was the representation. But now the question is, okay, you have given 292 plus 4 seats to the provinces. Which province will get how many seats? Which province will get how many seats? So that again decided on the basis of population. So what was the basis on which it was divided? Population. And the formula that they followed is, for every 1 million population, 1 seat will be allocated. So any province which is having more population, they'll get more seats on the ratio of what? 1:1 million. And then to make sure that the representation in the Constituent Assembly is from all the community. That should also be ensured, that they should be from all the communities. To ensure that this is from all the communities, they made sure one thing, that the representation in the Constituent Assembly was bifurcated into 3 communities. And it was to be in basis of the population. So what are the 3 communities? One is the Muslims, Sikhs, and general. That means depending upon, let us assume, depending upon the total number of Muslim population in the country, proportionate number of Muslim representatives there will be in the Constituent Assembly. Proportion to that of the Sikh population, proportionate number of representation will be there in the Constituent Assembly. Apart from Sikhs and Muslims, all the other communities were clubbed as general community. And proportion to their population, there will be representation in the Constituent Assembly. So this was the scheme that was devised. And by July 1946, the Constituent Assembly was also elected. But however, do you know when the Constituent Assembly met for the first time? So although they were elected way back in June 1946 itself, the Constituent Assembly met for the first time on December 9, 1946. December 9, 1946. And then that was the first day when they met. On December 13th, there was something historic that has happened. December 13, 1946. Something that was historic in the Constituent Assembly. What was historic in the Constituent Assembly? On December 13, 1946. December 13, 1946, Pandit Jawaharlal Nehru introduced what is called as the Objectives Resolution. So what is the very purpose of this Constituent Assembly? I have not completed this Constituent Assembly, a little bit more to discuss, but let me just pass it here right now. On December 13th, 1946, there was something which is called as Objectives Resolution, which was introduced in the Constituent Assembly. Have you ever heard of this word Objectives Resolution? What is this Objectives Resolution? What is the very purpose of the Constituent Assembly? The very purpose of the Constituent Assembly is to draft the Constitution of India. Suppose if you want to construct a building, what is the first thing that you will take care of? Foundation. So this Objectives Resolution was like a foundational document as to how the entire Constitution has to be drafted. What are the philosophies, what are the values it has to enshrine. So this foundational document was introduced by Pandit Jawaharlal Nehru. He moved this through what is called as the Objectives Resolution. In fact, what is the significance of this Objectives Resolution? In fact, it was later this Objectives Resolution was modified and it was put in the present Constitution as the preamble to the Constitution of India. Okay, so try to remember all those things. So there are a little bit more things that I want to discuss about the Constituent Assembly, but I'm not moving it right now forward. So try to understand. I'll just wind up the class right now, but let me summarize with regard to the Constituent Assembly. So try to understand that the Constituent Assembly of India was established based on what? Cabinet Mission Plan, which was sent to India, which basically had 3 cabinet members. The idea is that they have decided that they are going to transfer the power to India. Before transferring, they are willing to give independence to India. So before doing this, what they wanted to do? Before they're doing this, they wanted to have a body which will draft the Constitution of India. And then for the very purpose, this mission was sent. They held consultation with the political parties and they came out with an idea, okay, the Constituent Assembly will be set up. And this Constituent Assembly which will be set up, is it an elected body directly or indirectly? It's an indirectly elected body because they wanted to set up this body immediately. And the Constituent Assembly, this body will have representations from both the princely states as well as the provinces. That is the scheme of design. And from the provinces, it will be through an indirect election. From the princely states, it will be through nominations. And when I say from the provinces, it will be by an indirect election. Who will have the right to vote and elect the members to the Constituent Assembly from the respective provinces? Already in each and every provinces, there was a provincial legislature. And these members were elected already. And only those members will have the right to vote. Say, for example, in Uttar Pradesh, anybody from Uttar Pradesh? Let us assume Uttar Pradesh to be a province at that point of time. Today in Uttar Pradesh State Legislative Assembly, how many members are there? Any idea? In Uttar Pradesh Legislative Assembly, 403. You are right, 404. At the time, there was one nomination was also allowed from the Anglo-Indian community, which has been done away with right now. So right now, the number of assembly members in the Uttar Pradesh is 403. So similarly, at that point of time, there were 11 provinces. So the elected members of those legislative provincial legislature, only they will have the right to vote to elect the members to the Constituent Assembly from their state. So it was by elections in case of the provincial legislature and nomination in case of the princely states. In this way, it was done by June, July 1946. But however, they did not meet for a long time because the princely states did not cooperate. But however, the first meeting happened in 9th December, and then subsequently on 13th December, they introduced, or Pandit Jawaharlal Nehru moved what is called as the Objectives Resolution. This Objectives Resolution is nothing but it is the foundational document for the entire Constitution, which is today modified as what? Today modified as the preamble to the Constitution of India. And what is the principle on which the number of members in the Constituent Assembly was decided by the Cabinet Mission? Based on population. And the population is generally to be in the ratio of 1:1 million. And in order to ensure that the representation in the Constituent Assembly is from all the communities, so they classified the communities into 3 types. What are they? Muslims, Sikhs, and apart from the Muslims and Sikhs, it is a general community. So this is the scheme largely, if at all any question comes from the Constituent Assembly, it will come from this particular scheme of the Constituent Assembly. There are 5-10 minutes of discussion which is still pending, but I'll do it in the next class. Okay. So try to revise what is there in the Constituent Assembly. I'll just continue with the Constituent Assembly in the next class. Probably 5-10 minutes I'll complete the Constituent Assembly. Then I'll go to a topic of what is called as a historical underpinning. Again, this topic of historical underpinning is also, I think it is a little vague topic, okay? But again, just to give an idea, I'll have to cover the topic also. So probably in the next class, when is the next class? On Monday. So when we come on Monday, I'll try to complete this historical underpinning. And then probably from Tuesday, we'll go to the preamble to the Constitution of India. But whatever I've discussed till this point of time, you can expect 2-3 questions in your prelims. From the themes, from the keywords, from the majorities, from the historical underpinning also, sometimes they can ask you one question. So 2 to 3 questions can already come, although we have not started the Constitution. Okay, so these are also important. All right, so any questions from what you have discussed? Online students, as well as the offline students? Any question? Yes, because they are mentioned in the Constitution, I'm saying that. Without it is mentioned in the Constitution, how I can tell that? So all these types of, only these 4 types of majorities are recognized in the Constitution. Okay. Although it is not exactly mentioned as what is called as effective majority. They say that to be the then majority. But the then majority means it is effective majority and it is calculated by this way. Okay. And they do not use the word simple majority, but rather in most of the places they use the majority of members present and voting. So when you say majority of members present and voting, then it is simple majority. But they use the word what is called as absolute majority, or they use the word what is called as the special majority, and different types of special majority. Any other questions? Online students, any questions? Okay, so tomorrow before you come, if you want, you can read the topic of historical underpinnings. Okay, you just read that and come when you come to the Monday's class, and also try to revise all these things, whatever I have given. Any doubts from our previous class? No doubt? So can I ask any question? And if somebody is not answering it properly, then we'll extend the class by half an hour. Is that okay? Is that all right? Ready for this challenge? So somebody is saying, no, sir, thank you very much. Vaishali is saying, no, sir, thank you very much. All right, let me just put this particular question. Just tell me which of the following is the federal feature in the Constitution. Okay, independent judiciary, division of powers between the center and the state. Is it a federal provision? Independent judiciary, is it a federal provision? Independent judiciary is not a federal provision. Just think about this, whether independent judiciary is a federal provision or not. Just think about this. I'll take the answer in the next class. If you say yes, why it is a part of a federal provision. If you say no, why it is not it is not a federal provision. So we'll discuss that in the next class, and we'll complete this historical underpinnings also next class. And from Tuesday, we'll start the preamble. Okay. Thank you very much. We'll meet again next week. Please wait one moment. There is also a Zoom session which will happen at 8 o'clock today. So you can attend it from your home. You can just attend the meeting online. So that will be a doubt session. So if you have any doubts from the last 4 classes, if you're not comfortable asking it right now, so what you do, or you just go and revise it before 8 o'clock. So I'll come for the doubt session, which will be through a Zoom meeting. And then whatever questions you have, you can ask. Okay. So you can just go through and revise whatever you have, and whatever doubts you have, just note it down. And we'll meet at sharp 8 again for the doubt session. Okay. Thank you very much.